Ladies and gentlemen and members of the City Council, I'm going to call this meeting to order at 6 p.m. First, roll call. Don.
President St. Amand.
Present.
Vice President Boyd.
Present.
Director Cordell.
Here.
Director Griffin.
Here.
And Director Ritora.
Here. Very good. Director Ritora, would you lead us, please, in the Pledge of Allegiance? If you would rise, join us.
Please join me. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Please be seated. Posting of agenda declaration.
The agenda for tonight's special board meeting was posted on Tuesday, January 25th, 2022.
Okay, thank you. Conflict of interest declaration.
Ritora, none.
None for Boyd.
Cordell, no.
Griffin, none.
St. Amand, none. But that being said, I must let you know that I am an employee of the federal government. That being said, anything I say tonight, any of my opinions are mine alone and do not necessarily reflect those of my employer or the board of directors of the Water District. Thank you. Public questions and comments. This portion of the meeting is reserved for persons desiring to address the board on any matter not on the agenda and over which the board has jurisdiction. However, no action may be taken by the board of directors on any item not appearing on the agenda. Non-agenda speakers are asked to limit their presentation to 5 minutes. Public questions and comments on items listed in the agenda will be accepted any time the agenda is brought forth for consideration by the board. When you're recognized by the chair, please state your name and address for the record. Do we have any public comment? Okay. Do we have any telephone comment? All right, I see a red light. Then we'll move on to the next portion, board workshop. This is an informal meeting, a public workshop to allow you, the staff and consultants, the opportunity to discuss the Water District's filing the comprehensive adjudication and how it may impact your right to pump groundwater. So I'm going to go ahead and pass this off to the staff. Dawn, if you want to take over and ask the board to retire to the audience, please.
I want to welcome everybody that's here in the council chambers as well as those that are joining us online. Thank you for attending. I'm going to begin with introductions. I'm Don Zadiba, General Manager for the New Wales Valley Water District. To my right is Jim Worth. Jim is a partner with the firm of McMurtry, Hartsock, Worth in St. Lawrence, which has served the council as counsel for the district for over 30 years. Jim joined the firm in 1992. He presently serves as general counsel to multiple public agency clients, including agricultural and municipal water districts. He provides legal advice on all aspects of public agency representation. Jim has extensive experience in the areas of water rights, real property matters, environmental issues, and the California Environmental Quality Act, known as CEQA. Also eminent domain, transactional matters, and Brown Act compliance. His litigation experience includes prosecuting and defending CEQA matters, eminent domain actions, insurance coverage disputes, and water rights issues, including pre-1914 water rights. He successfully represented both public and private clients on matters before the State Water Resources Control Board. In addition to his work with public agency clients, Jim was the lead attorney in multiple cases arising out of his clients' acquisition of business assets, as well as workplace harassment. More recently, Jim has been providing legal advice on the Sustainable Groundwater Management Act, including the formation of the Groundwater Sustainability Agencies, and serving as general counsel to multiple GSAs. Prior to joining McMurtry, Hartsock, and Worth, Jim worked for a large insurance defense firm and handled all aspects of defense, including depositions and discovery matters, law in motion, mediations, arbitrations, and trials. Jim is admitted to practice before the California Supreme Court and all other California courts. To my left is Doug Everett. Doug is a partner with the firm of Murphy & Everett, having joined the firm in 2010. He's serving as special counsel to the district. Doug is an accomplished trial lawyer representing clients in complex litigation and real estate matters at the trial and appellate court levels. He specialized trial experience in disputes involving eminent domain, real estate, land use and CEQA water rights, and environmental matters. Doug has served as a lead trial counsel in many high-profile eminent domain and land use cases, both on behalf of public agencies and private interests. Over his career, Doug has represented a number of cities, counties, water districts, and school districts in connection with major public agency acquisitions, public works projects. He's also represented a number of commercial and industrial property owners and business owners in eminent domain actions filed by Caltrans and other local governments. Clients include small family-owned businesses, Fortune 500 companies, and nonprofit organizations, including churches. So this meeting has been noticed as a special meeting of the Board of Directors of the Indian Wells Valley Water District to allow the board to attend in compliance with the Brown Act. The board will not be answering questions or participating in the meeting due to the nature of the presentation being based on the comprehensive adjudication. This meeting is a follow-up to the meeting that took place in these same council chambers on December 14th. The slides that are going to be presented tonight are essentially the same as those that were presented at the first meeting, but we have a lot more people here tonight and probably joining us online that didn't see that presentation, so if you saw it before, please bear with us. I expect there's probably going to be a number of questions and comments. It would be more efficient as far as the flow of the meeting if we can wait until the information is presented, probably about 20 minutes or so for the presentation. This meeting is being live streamed, so we'll likely have people calling in, as well as questions here in the council chambers. It's also being recorded, so please, if you do have a question or a comment, come to the podium and please state your name for the record. Also, if you're calling in, we ask you to please state your name before you present your comment or your question. So at this time, I'll turn the meeting over to Jim Worth.
Thank you, Don. So this presentation will take two parts. I'll do the first part, and my intent is to try to provide a brief overview of the various water issues and lawsuits that are facing the basin, and bring us up to a timeline right around the filing of the adjudication, and then I'm going to turn it over to Doug to take it from there. So with that, I'll go ahead and go. The primary goal of the informational workshop tonight is to help educate the public about the comprehensive adjudication that's been filed by the Water District. One of the primary goals of the district in filing the comprehensive adjudication is to bring certainty to the water rights within the valley now and into the future. Now, we'll talk about the Navy as well later, but importantly, a comprehensive adjudication, it is the only type of lawsuit wherein the federal government has waived its sovereign immunity and said that it will participate in a state trial if it's to determine the Federal Reserve water rights, which this lawsuit will do. In addition to determining the Federal Reserve water right for the Navy, there's also some federal entities that manage land within the Indian Wells Valley Basin, and that would be the Bureau of Land Management as well as the Forest Service. Combined, the Forest Service, BLM, and the Navy, they manage 301,000 of the 382,000 acres that overlie this basin. So it's important when we're talking about water rights and certainty that the Navy participate and that their right be quantified, and this is the only way to do that. By statute, a comprehensive adjudication is required to involve all persons, entities that may claim a right to pump or store water from the Indian Wells Valley Basin. In this respect, the district has or is in the process of serving over 22,000 parcel owners and pumpers with service of the cross complaint for the adjudication. And some of the goals that can be accomplished through an adjudication and the inclusion of all potential pumpers and those with rights are, it will provide finality as to the quantification of the water rights with the final judgment and the adjudication. It avoids piecemeal or future litigation on this subject. Once you have a comprehensive adjudication, you're not going to have subsequent lawsuits by pumpers trying to redetermine their rights. The comprehensive adjudication should be done one time, and it should be final and long-term. And that's the third thing it does. It helps bring about a long-term solution for the basin's water deficit. Now, the comprehensive adjudication will ultimately determine and likely quantify all of the groundwater and storage rights within the Indian Wells Valley Basin. For this reason, it's important for private well owners, groundwater pumpers, and anybody who might claim any right to store or pump water within the basin to participate in the adjudication. This will allow you to assert and protect any rights you may claim. We'll go into greater detail, primarily Doug will, about how you can join and participate in the lawsuit if that's how you choose. So there's a number of public agencies that are involved with the water issues right now. So I want to give you a brief overview of who they are and what their roles are. So I'll start with the Indian Wells Valley Water District. That is the entity that is hosting this meeting tonight. The Water District serves primarily the residents of Ridgecrest and has about 14,000 connections. It's a county water district formed pursuant to California water law, and the primary purpose of the district is to provide water to its customers. The city of Ridgecrest, they're involved. I think you all know we're sitting in the city chambers, and they are a land use planning agency within the basin, and so they are part of the Indian Wells Valley Groundwater Authority that we'll talk about a little bit more. The county of Kern, they're also involved with the Groundwater Authority, and much like the city, the county has land use planning authority over the county, those lands within the county outside of the city of Ridgecrest. And then for the last public agency within the basin would be the Indian Wells Valley Groundwater Authority. This is the agency that was recently formed within the past 5 years, I think 2016, pursuant to SGMA. And the whole goal of the GSA, the formation of the GSA, was to develop and implement a GSP that brings the basin into sustainability. The Groundwater Authority is governed by a 7-member board. The three that I just mentioned, the Water District, the city, and the county of Kern, as well as San Bernardino and Inyo County, those make up the 5 general members. They are the voting entities, and they have all the voting rights. There are 2 ex officio members of the Groundwater Authority. That would be the Navy and the Bureau of Land Management. They participate in the meetings and provide in-kind services in many different ways, but they do not have the authority to vote. So it should be noted that the Groundwater Authority is one entity, but all of the agencies that make up the Groundwater Authority, they're all separate and distinct public agencies, and they're all governed by their own body, city council, board of directors, board of supervisors. And as indicated, the purpose of the formation of the GSA, the Indian Wells Valley Groundwater Authority, was to develop and implement a GSP. So those are the parties. There's also Searles Valley Mineral, you might hear, or Mojave Pistachio, Meadowbrook, some of the larger pumpers. They're involved in some of the lawsuits. So if you've heard their names, that's probably why. So now that we've talked about the parties, it's important to realize that the Water District did not file the adjudication in a vacuum. Present circumstances within the Indian Wells Valley cannot be ignored when talking about the adjudication. And it should be noted that although the Water District is a member of the Groundwater Authority, the comprehensive adjudication was filed by the Water District as a separate entity. So I think it's important to realize the district has talked about hopefully trying to get an early resolution, get a lot of the major stakeholders and public involved and try to reach a resolution on this. And so there's a little bit of history that we think helps us out. 20 years ago, many of the major stakeholders and major pumpers recognized the importance of water and the potential issues that were facing the basin. And a good example would be the Indian Wells Valley Cooperative Groundwater Management Group. Slide 1. The group was formed in 1995 out of concern for negative impacts of concentrated localized pumping in the intermediate area by major producers. They're having some issues back in 1995. The original members of this group include the Navy, the Kern County Water Agency, the city, Inyo Kern, CSD, the Water District, Searles Valley Minerals, Eastern Kern County Resource Conservation District, and the Indian Wells Valley Airport District. After the initial formation in 95, additional members would include the Bureau of Land Management, Quist Farms, Kern County, and Mojave Pistachio and Nugent Farms. The objectives were to, and some of the objectives are similar to what you'll see in the GSP, limit and distribute additional new groundwater pumping within the basin that will, in a manner that will minimize adverse effects to existing conditions and pumpers. Water conservation, to encourage and implement water conservation measures. Encourage the use of recycled water within the basin. That's an active issue right now that the Water District is talking to the GA and the city about. Also, more data gathering and sharing of information within the basin amongst the members of the group. And then to explore potential water management actions that could help address the water deficit. Now, the cooperative group, it didn't have any real authority or any type of statutory power, but they did accomplish a number of things, including the relocation of major pumping away from the intermediate area. They did groundwater monitoring and water quality sampling. The Navy drilled wells, and the logging was provided by Searles Valley. They participated in the brackish water treatment study, and they were instrumental in the development of the Brown and Caldwell groundwater flow model. So the Water District hopes to involve all the interested persons in the comprehensive adjudication, and we think that if we can do that, that we can make progress, and it won't be a long, protracted process, because it's been shown that in the past, when the major stakeholders and the public get together to address these issues, progress can be made, and that is one of our primary goals here. So the cooperative group disbanded in 2018 after the formation of the Groundwater Authority and subsequently the Technical Advisory Committee. We should be on slide 4. Sorry about that, the Sigma slide. So I'm going to keep rolling. Okay, so the Sustainable Groundwater Management Act, which is why the Groundwater Authority was formed, became effective January 1st, 2015, and is the state's first attempt to regulate groundwater from a statewide basis. SGMA requires medium and high priority basins to develop and implement a GSP that will achieve sustainability within 20 years. The Indian Wells Valley Basin is a high priority, critically overdrafted basin as determined by DWR, which set the timeline for sustainability by 2040. Slide 5. As a critically overdrafted basin, the GA, the Groundwater Authority, was required to prepare and submit a groundwater sustainability plan by January of 2020. That was done, and it was actually recently approved by DWR within the past week. Now, when we talk about sustainability, what that means is that you have to manage your pumping now and into the future so the basin doesn't experience any what they call undesirable results. And undesirable results could be chronic lowering of groundwater levels, significant and unreasonable degraded water quality, significant and unreasonable reduction of groundwater storage, significant and unreasonable land subsidence, and then there's depletion of interconnected surface water and seawater intrusion, which really isn't a big issue up here. So with that said, the GSP that is for this basin estimates that the safe yield of the basin, that means it estimates the water coming into this basin every year is 7,650 acre feet. Current pumping within the basin is anywhere from 22,000 to 25,000 acre feet. So as you can see, there's a large deficit between supply and demand. And SGMA requires that this community address that and take care of that and make sure that this basin is around for the next 50, 100 years. Domestic pumping alone within the basin approximates about 11 to 12,000 acre feet. And the way it's been broken up and allocated to the various pumpers is de minimis pumpers have been allocated 800 acre feet. De minimis pumpers are estimated to pump 800 acre feet. The water district, 6,500 acre feet. Inyo Kern, about 100 acre feet. The small mutuals, 5 and over wells, 5 persons over wells, 300 acre feet. And then Searles Valley pumps approximately 217 acre feet to serve the domestic needs with those residents over in Trona. And so with the Navy pumping 1,450 acre feet and Searles Valley pumping a total of about 2,400 acre feet, just that domestic and industrial totals 11 to 12,000 acre feet a year, which is still more than the estimated safe yield of the basin. So additional steps will need to be taken. Now, the way the GSP was set up is that we've talked about the Federal Reserve water right, and the GSP has basically allocated the entire 7,650 to the Navy's Federal Reserve water right. So the Navy is entitled to use that, whatever it needs out of that Federal Reserve water right. It's currently pumping about 1,450 acre feet, and the remaining water over and above that 1,450 acre feet to the 7,650 acre feet have been allocated to the domestic pumpers that I mentioned earlier. And the importance of the allocation is that it's the basis for the replenishment fee. So if you have to pump more water than what you've been allocated through the GSP, you're required to pay the replenishment fee of about $2,100 an acre foot. From the water district standpoint, we have to purchase we received about 43. We pumped 6,300, so we're paying the replenishment fee on about 2,000 acre feet a year. The first year, 2021 was the first year we paid it, and it was to the tune of just over $4 million. So that's how the replenishment fee was imposed. And the way it works is the water district just charges the water district customers the replenishment fee based upon the amount of water that you use. We collect those funds, and then we transfer those directly to the Groundwater Authority, who uses those funds for activities that are to bring in imported water supplies, or new water, if you will. And which is a part of the reason some of the lawsuits we'll talk about. Searles Valley and Mojave Pistachio, they did not receive any, I'll call it excess Navy carryover water rights. So every acre foot that Searles pumps or Mojave Pistachio pumps is subject to the replenishment fee of 2,000 acre feet, which is why you hear them saying it's going to cause them to go out of business. I'm not saying that's a true statement, but that's the basis of that statement. So getting close to the adjudication, and be aware that there's probably over 6 or 7 lawsuits that are currently pending regarding water rights within this basin. The adjudication is merely one of those. So it's important to note that there's other lawsuits involved. And so just to let you know kind of why the district took the action, the first lawsuit right before the GSP was approved was filed by Mojave Pistachio. And it was a lawsuit filed against the Water District, Searles Valley Mineral, and Meadowbrook. And they requested a limited physical solution. So they did not name the Navy. So in that lawsuit, Mojave Pistachio was asking the court to determine the water rights of Mojave, Meadowbrook, the Water District, and Searles, and nobody else. The Navy wouldn't be involved. None of the other pumpers would be involved. So if that occurred, nobody that wasn't participating in it would not be subject to the judgment. But then again, you could see multiple lawsuits like this in infinity until everybody was satisfied with their water rights. By filing an adjudication, we're going to have one lawsuit to determine the water rights. So after the GSP was adopted, Searles Valley and Mojave Pistachio filed additional lawsuits in, I believe, September of 2021 or 2020, challenging the GSP and punishment fee and the related actions. So that case is ongoing. They're actually challenging the validity of the Groundwater Authority's approval of the GSP. Have no idea how that will go. The Water District is a party to those lawsuits, primarily because there are allegations in the lawsuits that are seeking to claim water rights superior to the Water District, so we're there to defend the water rights if needed. So you've got those 3 lawsuits that are going on. We're involved with the reverse validation. And now I'm going to go back to the limited physical solution that was filed by Mojave Pistachio against the 3 other pumpers. The district had 2 options with respect to this lawsuit. We could defend the lawsuit without the Navy and go through the process wherever that would lead. However, that would lead the district open to multiple lawsuits because the lawsuit would only pertain to 4 pumpers, and the district didn't want to just do a piecemeal approach to this problem. So the next option was, if we weren't going to defend that lawsuit, the other option was to file the comprehensive adjudication, which is the only way to bring the Navy into there, which requires us to bring all of the pumpers and those that might claim rights within the basin into the lawsuit. And that's what we've done. And that's all I've got. So I'm going to go ahead and turn it over to Doug.
Good evening, everybody. My name is Doug Everts again. And just a little bit more background on me. I was involved in both the Mojave River adjudication. I represented the City of Barstow and the Southern California Water Company. Was also involved in the Antelope Valley adjudication that was recently and finally resolved. Represented the City of Lancaster and the Rosamond Community Services District in that proceeding. Both have been resolved and both are working out quite well. One other lawsuit that as Jim mentioned, in the water rights context, there was the first lawsuit that was filed by Mojave Pistachios, which only named the Water District, Meadowbrook, and Searles Valley. There's another lawsuit that we haven't discussed yet, but there's a cross-complaint that was filed in this lawsuit, not only by the Water District, but by Searles Valley Minerals. Sure. Is that a little better? Okay, sorry about that. There's another lawsuit or cross complaint that is filed in the water rights lawsuit that was filed by Searles Valley Mineral. That lawsuit is also a cross complaint that seeks very similar relief that is being sought by the Water District. In this particular case, that matter has not been served yet, but it is out there. So that's a long-winded way of saying there's a lot going on out there. And I can say what the Water District is trying to do is bring finality, closure, and long-term sustainability to the basin. Backing up a half step, the GSP that Jim was referring to, that document clearly acknowledges two things. Number one, the Groundwater Authority and the GSP has no jurisdiction or ability to determine water rights and priorities, number one. And number two, the Groundwater Authority and GSP has no jurisdiction over the federal government and in particular the Navy. Why? There are particular laws that provide that the federal government is immune from litigation in state court and over water rights, but there's an exception to that. And this is really important for everybody to understand because it's important and to understand in part why the Water District filed this cross complaint. And that is the laws that I'm referring to, in particular, it's called the McCarran Amendment, provides that the federal government can be brought into a water rights lawsuit if there's a comprehensive adjudication that fully and finally determines all water rights within a given water source. And the reason this law was adopted was that the federal government and our legislature determined that it's appropriate for the federal government to participate if there is in fact going to be finality and certainty to determine water rights in the basin, including those of the federal government. So as Jim noted, the only way to bring the federal government to the table, and obviously the federal government is a huge and major player in this valley, is to in fact bring comprehensive adjudication. That's the comprehensive adjudication statute requires that we, the Water District or anybody filing an adjudication, comply with these requirements, and I'll talk about the mailing here in a moment, but it requires that we go through that process of sending out this mailing. I can say from my own personal experience and knowing from a variety of other instances that groundwater adjudications, though complex and involve a lot of parties, they are historically very successful in bringing finality, certainty, and long-term sustainability to a basin. And the goal in all of these matters is not to shut off anybody's water tap, but to come up with a solution that works equitably for everyone. That's occurred in the Mojave River Valley and also occurred in the Antelope Valley. With respect to the actual procedures in the comprehensive adjudication, as I noted before, we're required by law to serve notice to every parcel within this valley and also on all pumpers. It was a great undertaking. As Jim mentioned, I believe there were 20 to 22,000 mailers that went out. I'm sure that surprised a lot of people, and I apologize to the extent we can that we have to do that, but we have to follow these procedures. And again, it's to bring the federal government to the table and to participate in these proceedings. I can say that the lawyers for the federal government that will be participating in this particular case were actively involved in the Antelope Valley. They're good lawyers, good people, and they were very instrumental in working out a solution in the Antelope Valley case, and I'm confident that will occur here as well. I've received a lot of questions, obviously, about what's happening and why. And I want to be clear that, again, the reason that we served everyone with this mailer that many of you, if not most of you, have received is because we're required to do so by statute. I've received a number of questions and inquiries from what we call de minimis water producers, and what does this mean to me and what should I do about this? And we're working on that. One thing that we've discussed and that we intend to do is there are 2 upcoming hearings with the court that's now hearing all of these cases. The first one is mid-March, March 15th, and that's what's called a case management conference. Nothing of substance will occur on that date. No water rights will be determined. Nobody's rights will be negatively impacted at that hearing. It's a hearing to bring our trial judge, who we'll be meeting with for the first time, up to speed as to what's happening, and the judge will be receiving recommendations as to what are the next steps in this adjudication. One thing that and I need to back up a half step. The adjudication is not just the water district's lawsuit. The water district does not determine what does or does not occur in the adjudication. We can make recommendations, we can make suggestions, we can work with the other parties in the lawsuit, but at the end of the day, it'll be the parties cooperating and presenting something to the judge, asking the judge to potentially bless a solution, or alternatively, we cannot reach agreement on certain items. It'll be the judge that will ultimately make the decision at the end of the day, not the water district. One of the things that we'll be discussing, or at least the water district will be requesting from the judge at the March hearing, will address the de minimis producers. In many adjudications, for example, the Antelope Valley, a procedure was adopted where the de minimis producers were effectively, my words, exempted from the lawsuit and didn't have to participate in any extensive degree. Reason being is that the de minimis pumpers were determined not to negatively or adversely impact the sustainability of the basin or other producers. What we intend to do on March 15th, and in the paperwork we submit to the court prior to that date, is request that the judge effectively, it's a legal term of art, but pause, I'm saying that jokingly, but pause the requirement that minimum or de minimis producers participate in this lawsuit. If you'd like to, you're welcome to, clearly, but we want to provide to the de minimis producers, subject to court approval, that they don't need to participate at this particular point in time. The reason being is that the goal will be to have the experts on representing all the significant stakeholders to make their own assessment as to whether the de minimis producers actually need to be parties and participate in the lawsuit and the ultimate physical solution, or whether they can be exempted. The statutory scheme under the comprehensive adjudication allows a trial court to exempt producers up to 5 acre-feet a year. I'm not saying that's the magic number here. I know the GSP is 2 acre-feet a year, but the bottom line is we will be making that request of the trial court on March 15 to effectively give us a pause while we figure out to what extent the minimum de minimis producers need to participate in the lawsuit. Secondarily, there's historically a filing fee associated with filing an answer in any lawsuit. In Superior Court in California, at least in Orange County, they require the first 18 parties to make that provide for that filing fee. We're probably closing in on that number now, but not right there. But regardless, there is a hearing currently scheduled for, I believe it's April 8th, but the first week of April, that we're going to go in and request that the court waive any filing fees that would be otherwise required by de minimis pumpers. That date's a little further out in the future than I would prefer, so our intent is to go into court here very shortly and ask the trial court judge to expedite that decision and make a ruling on that issue sooner rather than later, so we can bring some clarity as to what's happening with the minimal producers. We intend to keep everyone up to speed as much as we possibly can. If you haven't seen it already, we can log on to the district's website, and there's a tab on that website entitled Basin Adjudication. There's also an FAQ, frequently asked questions, on that link that will provide answers to many of the questions that some of you have. A question that I'm getting frequently from a number of people is, how do I file an answer if I want to? We're going to put up a posting, hopefully by the end of this week, as my goal, maybe no later than Monday, but that will provide specific instructions that if you do want to file a document with the court, it'll give you information on how to do that. And that, I think, is pretty much where I am, Jim, unless we want to open it to questions. Yeah, and just maybe in closing is a couple other things. We are in contact with the Department of Water Resources, California State Department of Water Resources. There are some preliminary steps there, and I should emphasize the word preliminary, to have the DWR be involved in the facilitation process to resolve some of the issues in this case, and ultimately any physical solution. And a physical solution is just jargon for a settlement and a solution that works for all the parties. But ultimately, at the end of the day, we'll have to have DWR bless whatever comes out of the basin adjudication. And again, I'll say this again, the goal here is to bring finality and certainty and closure to the water rights and water matters that affect the valley, and to allow sustainability and growth. With that, I'm concluded my presentation.
Okay, I think the presentation is done, so at this point, we'll open it up to questions or comments from the people that are here in the chamber. And once we've had all those questions and comments addressed, we'll open it up to the people on the phone. So anybody that has a question or comment, please step up to the podium and state your name.
Good evening. My name is John Baker. I'm in your current private pumper. To elaborate on some of the things you just said, you talked about March 15th possibly giving the de minimis users an exemption. And then a little later we talked about the 8 April waiving a fee. Those are both past the deadline for filing our answer. How does that work?
You should go ahead and file, Go ahead and file the answer. If I had my druthers or ability, I could extend that, but I can't do that unilaterally without court approval. But that answer is just, you should have that in the packet that you received. It's a 2-page document. So I would encourage you, if you are a producer, to go ahead and fill that out and file it. And as I mentioned, we'll be posting some information on the district website that will show you how to do that. But as I mentioned, we are going to go into court shortly to request that any filing fees be waived. So I would keep an eye on maybe the district website to see the status of that and file the answer, hopefully after we get court approval to waive the filing fees.
Okay. Next question I would have, as a private pumper, if we don't get the exemption for the private pumper, the de minimis user, and we do not file an answer to the cross complaint, do our rights still get taken into consideration?
That's a very good question. At the end of the day, the district's goal is not to eviscerate or impact people's water rights to the extent possible. By not participating, what I'll say is the primary risk is that decisions will be made without participation, assuming no exemption, and that's the risk. How the court ultimately will treat de minimis pumpers, I don't know. Obviously, municipal use and water for homes is the first priority, so I would be stunned if a court would do anything to negatively impact that, but what conditions the court may put on that could be impacted and ultimately decided by the trial court judge.
When the court would look at that, in past history I would guess, when the court would look at the de minimis user or the small water company per se,
Sure.
And they haven't filed a cross complaint, how does the court know that those people exist and those parcels exist? And how does that get put into the final judgment?
Good question again, and I'm going to be the first to admit that I'm not an engineer or hydrologist, but I'm a lawyer. But I know the people that know more than I do have the ability to figure out by various means to determine what kind of pumping is out there, whether it's aerial or whatever. But maybe you can help me out with that too, Don. But there are means to figure out who's out there and who's not.
Okay.
And I should be clear on the hearing on the 15th will not be to secure an exemption for de minimis. It'll just be asking the court to say, let's put that on the back burner for now while we look at really the major pumpers and what their issues are.
Understood. Then I guess my final question, and I don't know if there's an answer for this or not, but as a landowner and pumper and somebody that, say I do join the cross complaint and I decide to sell my property 3 years down the road or try to sell my property with this litigation going on, how does the water rights pass on, my cross complaint pass on to somebody who would buy my property?
The adjudication, the way it's currently structured by giving notice to all landowners, will be binding upon all land, and if you sell the property, it'll be binding upon future owners of that land.
Perfect. Okay. Thank you.
Mm-hmm.
Good evening. My name is Frank Bellino, and in full disclosure, I'm one of the small farmers out in Indian Current with 10 acres, using approximately 50 acre-feet a year. Some of the other larger farms have gamed the system. I'm sure you're aware of it. If you aren't, then you just haven't had your ear to the ground. They've run their water 24 hours a day, 7 days a week, building up their allotment. Now, I would have too, but I can't afford it. I'm not above doing something that's to my advantage with something I particularly disagree with. Is this being taken into account? How is it adjudicated? Do you just say, well, we've got X acre feet, to give out. We're going to go down and just do a proportion for each person, because if that's the way it's done, that's grossly unfair to people who have gamed the system. And I'm not going to rat who my particular friends are, because they are friends. But it has happened. Second, you keep talking about a filing fee. I've been told it's up to $1,000. Is that a fact, sir?
For the first 18 parties, yes. And our goal is to have that eliminated for anybody that's a small producer. And when we get to 18, I think we're close to that. It'll be a non-issue regardless.
Well, I'm 50 acre feet, so I'm obviously over the de minimis standard, although I have shut my orchard down, right, and it is non-producing at this point and will be in the future. It'll be firewood starting in about 3 weeks. Doesn't matter. I'm still listed as 50, and I just want to make sure I'm not going to end up getting, I want to keep my water rights, is
Understood.
what I'm saying.
Yeah, I would encourage you to keep your eye on the district's website on the filing fee issue, because I know that's an important issue to everyone, and we intend to update people on that issue. And if you are pumping in the neighborhood of 50 acre feet, I would definitely encourage you to file the answer with the court too.
Oh, I plan on filing, but I'm not going to pony up my money until I'm guaranteed if everybody else is going to get it for free. I am too. I don't trust the county to give it back to me, because I have enough experience with the federal and state governments to know that they're mighty fast to take it, but they're really slow to give it back.
Your earlier comments about parties gaming the system and not wanting rights just divvied up proportionally as to who's pumping now. What's the old saying? Whiskey's for drinking and water's for fighting. I'm sure
Right.
some of
Mark Twain, 1851.
Yeah, exactly. So I suspect there will be positions taken by some of the major stakeholders against one another. I don't want to state what they're going to argue up here, but I can assure you that those issues will be vetted in the court. And again, ultimately, the judge is the final decision maker. The goal, obviously, is not to have the judge decide some of those issues if the parties can come to agreement that works for everybody. But at the end of the day, if someone's being unreasonable and the judge needs to make a decision, we'll go that route to address those people.
All right. Thank you, sir.
Sure.
Ron Kosinski, and thank you for all being here. Doug, you're mentioning de minimis users, and most of your talk about people that are small pumpers. How about the potential de minimis user, someone who has 2.5 acres that is presently not built on or anything that in the future that might occur? So where do they fall into this? Because they're not pumping now, but 5 years down the road, they may say, I'm going to put a house on there and put a well in. How does this affect them?
That's a good question. What has occurred in other adjudications, like I can't state conclusively what will occur now. Sorry. What will occur now. What has happened in Antelope Valley, for example, is if someone who does not have a well but wants to come in and drill a well, they have to make an application to the water master, who is the water master is the term of art, but ultimately it's the person or entity or agency that will oversee the physical solution that comes out of the case. But what will likely occur, I can't say it will occur, but what will likely occur, there will be a process for whoever wants to drill that well to make an application to do so. There may be some fees associated with that, I don't know. But there's, as you know, there's a limited supply of water in this basin, and the court will need to account for that if someone wants to add new pumping to the basin.
Is there any reason that someone owns a parcel of land, I'm talking 2.5 acres, 5 acres, whatever, sure, is there any reason they cannot put their, and be party to this suit? In other words, go ahead and file their name, parcel number and such, whether or not they have a well or not?
Any landowner can file an answer in this lawsuit.
Okay. That's what I want to be aware of, because there are a lot of parcels out there, and I just don't want to think that any parcel that I have or someone else has becomes worthless because they can't get water to it.
Understood.
So I think the recommendation would be, if you have a parcel out there that you foresee you may or may never put a well in, you ought to go ahead and answer.
Yeah, and obviously, I know you appreciate that I can't give legal advice,
right,
but
exactly.
We are required to give notice to every parcel for that very reason.
So all I'm really asking is, if you don't have a well, you can still go ahead and become
yes.
a participant. Okay, thank you.
Yes.
Hi, I'm Skip Gorman, a resident of Ridgecrest, and I have 10 acres in town. I think I water the local rabbits mostly. De minimis. Doug, I'm interested in knowing how the judge will make the decision. I'll back away and lead up to that. The just recently approved, what do we call it? The Groundwater Sustainability Plan?
Yes.
That's it. That seems to have accommodations. Well, okay, one thing, the Department of Water Resources has approved that plan, I guess, conditionally, with about 19 areas they want more words about. Am I right about that? Everybody's looking at me.
I am still digesting that decision, but I think you're generally correct.
Sure. And the plan, because it'll be reviewed in about 2 years and then some years after that and at different milestones throughout its life for the next 20 or 40 years, it's a kinetic plan in that it's changeable as conditions warrant. I worry a bit. I feel comfortable with a changeable plan. I worry a little bit about the plan that comes out through adjudication, the plan that Moses comes down from the mountain with that's hacked into rock. It doesn't appear to be changeable. The judge has spoken. This is how it's going to be from now and forever. Am I unnecessarily concerned with that?
I believe so, and let me explain. Another example is the Antelope Valley, and in most adjudications, there's a process built into the physical solution to revisit virtually any issue upon application to the court. Obviously, conditions change. Either over a period of time, there could be more water, there could be less. In the Antelope Valley, that was a hot topic as to the time period that would be required to wait before revisiting, for example, the safe/sustainable yield. Some parties wanted to wait a longer period of time so that the procedures and mechanisms could be put in place. Others wanted a shorter period of time. At the end of the day, it was a little bit of sausage where we landed in the middle, but there were procedures built in to address changes, and in fact, parties can make application to the court to revisit issues should they be needed.
And Doug, has it been your experience that changes have occurred and were entertained and indeed happened?
They are when necessary, yeah. And usually it doesn't get to the court because at this point in time, once the physical solution's in place, it's really a function of engineering to determine what changes are needed. Again, if there's more water available, sure, things can change, or a variety of things. If different procedural mechanisms and accounting mechanisms need to be changed, yeah, I think at the end of the day, what everybody wants is something that works for everyone. If it needs to be changed, then it needs to be changed.
Doug, thanks. I imagine in my mind's eye, this will be my last question, how the judge, quote, makes his decision. It'll be more than one decision. It'll be a whole bunch of little decisions that add up, I imagine. All the participants will be seated along a very long table, and they sort of all yell at the same time, or if the judge is smart, he'll say, okay, you, Doug, you talk with, well, this guy over here, I'll say Jim Markman, and you guys duke it out while I listen carefully, and I'll be loaded for bear to make a decision after I hear everything there is to hear. Does that make more sense? Is that about how the process will go?
Let me give you two examples, both, again, the Mojave and the Antelope Valley. In Mojave, what happened shortly after the lawsuit was filed was a group of stakeholders represented by the actual stakeholders, lawyers, and importantly, the engineers and experts on water itself. And we negotiated a physical solution with not much court intervention. At the end of the day, there were only a handful of holdouts in that proceeding, and the main trial was was for the parties to present that fiscal solution to the court saying, Judge, this is a great idea, please approve it, number one, and number two, impose it on the remaining parties that are not participating. That's what occurred there. In the Antelope Valley, a few issues did need to be adjudicated because the parties couldn't reach agreement, and the judge decided certain distinct issues, but once those distinct issues were addressed, we were able to craft a fiscal solution that worked for everyone. And I should say that the federal government was very instrumental in that process and very cooperative. One issue here, I'm not saying it's a point of disagreement, but I know I've seen differing opinions from the experts, the engineers, as to the availability of storage in the groundwater basin. I don't know what it is. I'm not going to opine on it, but I know there are experts that disagree. If they can get to the table and say we agree on a consensus approach that it's X or it's going to be, excuse the pun, but fluid and change, that's another option. But at the end of the day, if the experts can't come to a conclusion, we may have to have the judge listen to both sides or multiple sides and decide what the best solution is.
My friend, thank you.
Okay. Hopefully I answered your question.
Pretty much. I hope the judge doesn't say, well, let's just cut that baby in half, give you each a half. I worry about the numbers. There's a disagreement, a basic disagreement between the two major parties. And I can't put good units on these numbers. One half of the group says there's only 8,000, or we're only using 8,000 acre feet, and the other says 25,000. A dramatic difference of opinion in physical numbers. That has got to be resolved, I think, before any decision is made. I'm surprised this plan went through with that number up in the air. You can address that if you'd like. Thank you.
Nick Panzer, Ridgecrest. I want to stay with the question of what would happen to someone that files the form answer. And I'd like to stay, we might as well use Mr. Bellino's facts. He's a small farmer, and he's debating whether to file a form answer and when and what it's going to cost him. But let's assume, for the sake of my question, that Mr. Bellino does go ahead and files and pays or not pays as he gets a bill for filing the form answer. My question is, would he have, as a result of doing that, a spot at the table equal to that of all the others that have filed a form answer, including the Water District, who's leading the charge? He seems concerned about equity and justice regarding his situation. And so I'm just wanting to understand whether, in fact, he will have an opportunity to address the court with his idea of what is a reasonable physical solution. That's my first question.
Whoever files an answer in the lawsuit will have a quote-unquote seat at the table. I could imagine that, depending upon the number of folks, that the judge would want some type of procedure in place to make it manageable, so we don't have 1,000 people coming up with different solutions, but everyone will have a say, and we'll just want to make it come up with a process and procedure to make it manageable so everybody's voice is heard, but in a way that makes sense for everybody so we can actually get things done.
If Mr. Bellino, again, does file and gets his place at the table with or without a group or in some manageable fashion, would he be entitled also to see what other filings have been made by the various parties? And would those be electronic? Would he have to show up in Orange County or in some library or some facility? Or as a result of filing the form answer and paying his fees, would he be entitled to electronic answer or the replies from all other participants at the table?
All filings should be viewable electronically. What I mentioned earlier is we're going to put up some information on how to file an answer. I will also investigate getting up some information on the website as to how to view documents that are filed with the court.
Okay. Last question. Let's assume that Mr. Bellino decides not to file a form answer, but he wants to be involved. He wants to be heard. He wants to be understood, understandably. Are you receptive to personally receiving his comments and ideas and suggestions to help you or facilitate this process?
Me personally, yes. The judge, no. The judge will not hear from anyone that has not filed an answer, but I think I'm speaking on behalf of the Water District. Sure, if anybody wants to propose a solution or anything, I'm all ears. I think I speak for everybody.
Thank you very much.
Mr. Panzer, if I may follow up with respect to people with respect to people having the ability to convey their thoughts or opinions on what may happen. The Water District, we are working with the Department of Water Resources right now to try to come up, we're not final, but to try to come up with a facilitation process, as you will, that would allow major stakeholders and the public to come up and express concerns and opinions, thoughts they might have on the various issues that are facing this valley. So we're hoping to create a separate venue outside of the court, and we're working in that regard. We're just not quite there yet. Thank you. That's all.
Ron Kosinski again. Mr. Panzer brings up a good question, I guess, is if, let's just say that many parcel owners, grab a number, 200 of them that have 2.5 acres, 5 acres, 10, whatever, that don't have wells, go ahead and file an answer. And how are they represented? I mean, are 200 of them going to show up, or let's say they don't show up? What happens in that case? Are they just sort of thrown out because, hey, yeah, you went and filed, but you're not here, so we're just going to throw out any concern for your property? Because I have a hard time believing, myself included, that if I filed for the parcels that I owned, large parcels, that I would show up in a court or show up at a table, and what would, I think you understand my question, I hope, please.
I do, and I don't have a definitive answer for you yet, but that'll be part of the process and things that we discuss with the court. What the court will be doing is setting status conferences or case management conferences on some kind of regular basis. And the purpose of that will be for the judge to hear from the parties as to procedures and next steps. And what you just described, that scenario, that's something that those that are already participating in the lawsuit will want to talk and get together and say, how are we going to deal with that scenario? I don't have a clear answer for you yet, but it's something that we're not going to ignore. And we'll obviously want to talk to the parties, talk to the judge, and figure out a way that everybody's heard.
So maybe that those non-well parcels get some kind of a notification if they filed saying we need information of some kind. Is
Yes.
that what you're saying?
Yes.
Okay. Thank you.
I guess if nobody else wants to talk, I'll ask a couple questions. Ralph Lockenmeyer, I'm a Ridgecrest resident. Just curious about how some of this de minimis users work out with parcels. Let's say a guy has 5 acres. A lot of the land around here, I think, can be zoned for 2.5 acres or something. If he gets 2 acre feet with his 5 acres and subdivides, does he get 4 acre feet then? How has that been handled in other places?
Those are good questions, and I'll be very honest with you. We don't have definitive answers on how each one of these different scenarios are going to play out. The goal, obviously, in any adjudication is to make it work for everybody. And the reason I mentioned earlier that we've decided and have gotten direction to put or request a pause for de minimis producers is to figure out the nature and extent to whether they are really needed to be part of this physical solution or not. And I don't have the answer to that yet, and I don't think we know. So I think some of the questions you're asking are well taken and well founded, but we don't have definitive answers yet, and it's going to be a process going forward. And I wish I had a better answer for you, but I don't.
How did Antelope Valley handle that in their de minimis users?
In Antelope Valley, As far as you're talking about like subdividing lots, I don't recall the specifics on that, though I recall it was addressed. I do recall that we exempted 3 acre feet or less from various items. What happens if a lot was later subdivided? I honestly don't recall. I'd have to go back and look at that.
Okay. It's not clear to me how the GSP, well, the GSP and the GA play into the court here. One of the things the GA is doing is charging a fee. Is that something that's going to be adjudicated by the court, or can they still charge fees for future something or other, importing water, for example?
I don't want to speak on behalf of the GA. I can say that some of the lawsuits that Jim was addressing earlier that were filed by Mojave Pistachios and Searles Valley are challenging the GSP. At the end of the day, what comes out of the adjudication will have to be considered by our trial court judge, and the GA has the right to participate in the water rights adjudication. It hasn't done that yet, but it does have the right to do so.
So I guess what I'm understanding is the GSP is under adjudication as well. The court can decide that, yes, that can stand, or they may take issue with it and say you got to change this or that.
I want to be careful with my words because the GSP is not being adjudicated in the water rights adjudication. It's being litigated in the other cases. But what will have to happen at the end of the day is that whatever the GSP, the ultimate GSP, and the physical solution will have to be harmonized in some respect, and DWR will be involved in that process.
I guess you're saying it all depends.
There are a lot of, it depends. Yeah, yes. There are, because of the multiple lawsuits and the issues involved and the stakes involved, there are a variety of things that are still to be determined. And I wish I had a definitive answer as to what will happen with all these things. I can't tell you, but I can tell you that with all sincerity on behalf of myself and the whole water district and the board, that our goal here is to really work on towards a solution that works for everybody and bring some finality to all this. It ends all the litigation at the end of the day.
And similarly, the GSP, I believe, provided for pools of water for some of the farmers that accepted it. That's all up in the air again?
There are a lot of issues that are up in the air right now.
Okay. Thank you.
Mm-hmm.
Good evening. Scott Heyman, Ridgecrest City Council and Director on the GA. So I have a question. I think it pertains with what Mr. Kaczynski had brought up earlier, and earlier when you were discussing the representation of the private well owners. So what I see is a cost, of $1,000 per filing or joining on.
Yes.
Has the water? I'm sorry. Go ahead.
I addressed that issue. Yes.
Right. And so my question is: has the water district entertained asking for legal representation for this group of people, and in doing so, asking for that being the responsible party for the cost of it?
I'm not sure I understand your question about
an attorney or representation for the minimus well owners or the other, the pumpers.
I don't know what you mean by the water district asking for legal representation.
Providing an attorney or representation for this group.
We can provide names if a group becomes organized, sure.
And is it something that with the Antelope Valley, or when they went through their process, did they have a similar type of a situation for representing the de minimis users?
They did, and it was a different scenario. In the Antelope Valley, that adjudication predated the comprehensive adjudication statute. And in that particular case, the only way to get the federal government involved, since there was no comprehensive adjudication statute, was to bring in all landowners, and they did that through class actions. And they brought 2 separate class actions. One was on behalf of non-pumpers. The other one was on behalf of small pumpers. And that process played out where there was representation through class actions. But now that we have the comprehensive adjudication statute, we can involve the federal government through the notice procedure that we're following now. But obviously, yeah, sure, we're more than happy to provide names. I've spoken with Mr. Decker about that in the past. And there are some names that I'm considering that I'd be happy to share with him. And as I mentioned earlier, the goal here in the short term is to see if we can put a pause on this process to see what involvement we'll need from the de minimis producers.
So along with providing the names, are you considering funding it or being a responsible party to pay for it?
I have not had that conversation with the board.
Okay. My other question is, listening to the earlier presentations and what the goals of this adjudication are, do you have plans to be more specific on what it is you're exactly wanting to have as an end result? What it is that you're looking for out of this adjudication?
Sure, but I'm just one person. The district is one party. It's going to involve all the parties to the adjudication working cooperatively together to come up with a solution. At the end of the day, we've seen what happened in the Antelope Valley, Mojave, and other adjudications. And the goal is to work on a solution that allows for continued pumping and growth. And that's obviously the goal here.
So is it safe to say that you're looking to increase the allotments for the water district?
That's not a fair question.
Well, it's specific. I mean, is it not? Or is it
I don't
to
think
change
that,
the...
I don't think that was a fair question, Mr. Heyman. What do you mean by that?
Well, I'm wanting to know what are the specific goals that the water district is wanting to pursue and see as an outcome from it.
I think I described that. And the water district's goal is not to take anybody's water rights. I don't know how to be more clear.
Well, I didn't mention take anybody's water rights. I just said it's a specific goal of the water district to increase their allotment. I
think I answered your question.
Okay, then is it a goal to change the replenishment or the natural recharge or numbers?
I don't have the ability to change the natural recharge numbers. The man upstairs does, but what those numbers are, I think, are subject to dispute, and that's what the experts need to look at.
Right.
And sure, if there is, again, example, there's a huge disagreement from what I've read as to the available water and storage. And I don't know what those numbers are, but if the numbers are higher than what's in the GSP, sure, that could change things.
So,
Same with the safe yield.
I disagree with you on whether or not it's a fair question, because what I'm asking you is specifics, because what I get when I listen to what was presented tonight, what I read on the front two paragraphs of the frequently asked questions is more of a general. It doesn't answer anything. You want sustainability, but we have a GSP that looking at sustainability plans. We have that outlook going on. But I'm asking you, what are the specifics that you wish to glean out of the end result of this adjudication? And I think that's a really fair question that people would like to know. So
I know your city attorney was actively involved in the Antelope Valley adjudication, and he can clearly answer your questions for you. With respect to those answers, the safe yield may be, or sustainable yield may be different from what's in the GSP. So if there's more water available than what's reflected in that document, then sure, there's more water available for everybody. Sure. I don't know the answer to that.
Okay, and that's fair enough. And so then back to the first question. So is that something that the water district would look into or entertain, the possibility of helping to provide legal counsel for?
As I mentioned previously, I have not had that discussion with the board yet.
Okay, good enough. Thank you.
Mm-hmm.
Hello, Kathy Russell, resident of Ridgecrest. Just to follow on with Scott Heyman's question about what are we really looking for. The allocation or what the inflow of water is 7,000 acre feet. The Navy has most of that. So I guess to that question, you're looking to the Navy to say they only use like 1,400 to make it more final. Like, is it going to be the adjudications just on the resources we have to date on how they're going to divvy that up? Because they said there's like a 32,000 acre feet outflow, so who's using all that water, and how are you allocating that for adjudication if you only have so much water to deal with? So how will that be divvied up if there's not enough to go around for the judge to see? That's how do you do that?
Yeah, that's a good question. And there are going to be a number of very bright and smart engineers, hydrologists, hydrogeologists that will come up with those solutions, but there are a variety of mechanisms. Recycled water is something that will obviously come into play here.
No, I understand that, but how would the judge decide that's what you're going for as adjudication, is to try to figure out who has water rights to the 7,000 acre feet we have, or is it to some other allocation? If all you're dealing with is that acre feet, how are you going to divvy that up so that these people have the same water right? Is it just a percentage of what's there? How is that kind of figured out?
And that'll play out through the court system. I don't want to say what other people are going to argue in the case, but I know some of the major stakeholders have differing views among themselves as to who has what water rights, and I suspect there will be some interesting arguments made in court as to who has water rights and who doesn't. I'm not focusing on the de minimis, but I'm talking about major stakeholders. How that plays out, I'm not going to speculate from up here, but that'll be something for the court to decide as to who has what water rights. Something that happened in the Antelope Valley, you mentioned the federal government. I have no idea whether that'll play out here, but the federal government's water right that was determined in that case was much higher than its actual pumping. And what occurred there is that the difference between what's actually pumped versus the federal government's actual water right was allocated to other parties pursuant to an agreement.
Well, that's kind of what you're going for, because the Navy right now has all the water they can do. The Federals, they can have it all, right? So is that the major goal, is to try to get them to realize you're only using 1,400 acre feet? Maybe then that's all you come to terms with, this growth?
We'll be having those conversations with the Navy as part of all the parties in this lawsuit, and my experience with all the players on that side, they've been more than reasonable, and they've got a desire to get this resolved too.
And I guess the other point is people that are selling property, et cetera, if this involves them, and I know there's been a lot of publicity in the newspaper, I don't know how that's impacting people wanting to buy or sell or invest in the community when they know, are we going to have water in 20 years or not? So I don't know if there's any goal of all the agencies to try to come together so there's not such a negative influence going out there to say we're going to make sure we have water, I guess.
Yeah, all fair questions and comments. The reality right now is that there's a problem and there are multiple lawsuits. So the Water District's goal, as I've been saying, is that we recognize there's a problem, but once we get everybody at the table, there, I'm sure, are creative solutions to address these issues.
I would hope so. Sometimes, though, you ask a bigger person to answer your problems for you, and you don't end up with the right answer. So putting it in the hands of somebody else sometimes doesn't always get you the answer that you thought you were going to get.
There are a variety of creative things that I can think of. I don't want to share them out here because I haven't discussed them with a variety of people, but I've seen things work in other adjudications that resolve issues that are currently facing this space, and I'm confident that will occur here.
And I'm encouraged that you said that if we don't get the answers we like, maybe there's a process to work through that?
Yeah.
Okay. Thank you.
Sure.
Okay, before we open it to the phones, are there any more questions or comments from those that are present in the chamber?
Lyle Fisher. I'm a domestic well owner, been for more than 40 years. I still have a problem with representing in court domestic well owners. Who will do that? You mentioned something when Scott Heyman was speaking, and I just want to hear a little bit more from you. And who will be representative? Because we don't know exactly how many domestic wells there are in this valley. The number runs between 600 and 800. Okay, we haven't identified all of them, obviously. So, but who will be representing us in court? Do we need to retain an attorney ourselves?
A very good question, and that's part of the reason that we're looking to pause the involvement of the de minimis pumpers, number one, to figure out to the extent that they need to be involved in the lawsuit, because if they don't, then that solves that problem, and I don't know if they do or not at this particular point in time. But if they do, then that's part of the process we'll work through. I don't have a definitive answer, but sure, if the de minimis pumpers can get together as a group and maybe have one or two lawyers involved with them, that's one idea. There are a variety of different things we can do to make sure that that group or your de minimis pumper group, if they can work together, that would solve a lot of problems. If we have 800 different people showing up wanting different representation, that creates a whole host of other problems.
That was the primary question, yes.
But if we can get that group together as a whole, then I think there are a variety of things we can do to address that. Have we done that yet? No, but can we? Yes.
Okay, very good. Thank you.
Mm-hmm.
Raymond Kelso, water drinker. First of all, I'd like to thank you for having this meeting. This has been very informative. A lot of the questions that I heard tonight were even being addressed 5 years ago when I originally came to started going to these meetings, because I live here. I plan on sticking around. I've got grandkids and 5 generations here, and would like to stick around. And I'm very, very concerned about our water situation. And on the negative side here, there has been a lot of talk and a lot of distractions and things that have went on that were just purely superfluous in the 5 years that I've been watching this. And I have not seen 1 quart of water being saved for my grandkids. Now, these meetings have done a great job of delay and distraction on that particular issue. But this here was an important and significant means of communication. And I would highly, highly recommend that this be done routinely and often. We've got to keep the communication open here so we can solve this problem. And everybody knows that there's only about a half a dozen people that are using over half of our water right now. And we've got to keep this democratic, and we've got to keep focused on what's important. And to me, it's important to have my grandkids have water like I did and like my grandmother did. Thank you.
My name is Peggy Breeden. I speak only for myself. I have a couple of questions. I'd like to go back to Ron's questions about the water that is not being used by properties that I'm not sure I understand how potential growth and the future of those properties are being addressed by this. And I know there had to be properties in the other lawsuits. I know it took Antelope Valley, 13 years to come to resolutions. How did they address those issues there, the properties that weren't using water? Because what it can develop is a rush to the pump. All those subdivisions of those properties that allow them more water than they would have had as a whole. Can you address how that happens, and how do we help those property owners use their land?
Good question, and I will be the first to admit I don't have a crystal ball how this will ultimately end up in this particular case. What I could imagine being a scenario is what I was trying to mention earlier, is that the court will need to ultimately enter a physical solution, hopefully by way of agreement of the parties, as to what's the pool of water that we're dealing with and what other means are there to have additional supplies. And then that we have the pot of water. And if for future owners to drill a well, what happened in the Antelope Valley and what I've seen elsewhere is a procedure is put in place where an application will have to be made to the water master, whoever's appointed by the court to oversee the judgment, to approve that process. It may require, and again, I'm not saying this will require, but it may require that if someone wants to drill a well, they need to help finance to their limited extent acquisition of additional water supplies, whether it's through paying a fee of some type for imported water or recycled water or purchasing water rights. And one thing I just kind of digress for a moment here. One thing that can come out of an adjudication is that overlying water rights in many adjudications can be transferred to other parties, and we've done that in the Antelope Valley and in Mojave, where a party that does have water rights can put their water rights up for sale through a process and sell those to new people. So that's something that could come out of this too. I don't know, but to indirectly answer your question, there are a variety of things that can be done to address that issue. How exactly it'll play out, I can't tell you definitively right now.
Can you answer from your experience in those two, Mojave River and Lancaster, how those were addressed in those particular suits?
In many instances, people they haven't needed to drill a well because they've had access to a water supply from a public water supplier and or a mutual water company of some type. But if an entirely new well is being drilled, it's not cheap. But if someone wants to do that, they've done that, they can, and they apply to the water master, and sometimes there are fees associated with that so that they can not only drill, but offset the impact that they may have on the basin in some financial way. What that is, I don't recall.
I guess a couple of things. Let me sum up here, if you can address any of those in my questions. Is I don't want to see our unused but owned, individually owned properties become not only worth less, but worthless. And that, to me, what it sounds like is what's happening here. If I own 10 acres and I want to sell it, I had better do it quickly before this decision comes, because it may, one, take away my ability to do water, to drill wells. It may take away my ability for future water because I haven't filed, as you referred to. And what it does in the long run is it limits the growth of the Indian Wells Valley. I don't want to see that happen. I want us to be able to live so we all have the water we need for what we need it for, and not to be piled up as worthless property.
Yeah, I understand, but at the same time, there's a significant problem of overdraft in this basin that needs
I
to be addressed.
understand that.
Yeah.
28,000 acre feet being used, 7,650 coming in. Unless there's billions, and I don't mean that casually, of acre feet of water in storage, and I don't think anybody thinks there's billions. Clearly, there's some water in storage. We need to know that. And I'm not sure how the court is going to decide that without knowing what storage is, and that is not part of the solution.
As I mentioned earlier, there are a number of lawsuits, even putting aside the district's cross-complaint, that are addressing water rights and physical solutions and judgments that could have all the impacts that you're describing. I think I'm speaking on behalf of the whole water district, that our goal here is that water district's a public agency here to serve the community, and we're going to try to do what's best.
I know you're not trying to put us all out of business. I know that. We elected you to serve us, and that's what we want you to do. We want you to serve all of us, whether we are part of the district or part of the valley. And I think that's important that we all understand. We're in this together.
Agreed.
And if we don't find the solutions together, we ain't going to be able to depend on the court to find those solutions, because they have to come from us. And that is why the issue of it isn't easy to do it, but we must.
I agree.
And that is where we are. And I thank you for that. And again, no criticism intended. Solutions must be found. I thank you. Look at the San Fernando decision, because when I read that, there was some issues of how they dealt with the unused and unpumped property.
I know the case, and thank you.
Thank you.
Ron Kosinski again. I'm sorry. SGMA, since it became law, pretty much defined a de minimis user, correct? I believe is 2 acre feet for domestic private use. I would think that would involve, if a de minimis user was created after that, it would be considered. In other words, if you put a well on a piece of property for your own domestic use, you now become a de minimis user. And I think, Doug, you said before that when the courts make this decision, since SGMA is part of the law, that any decision made has to take that into account Is that correct? Because it is
judge-
law.
The judge has to harmonize the decision, yes.
Exactly. So if the 2 acres is sort of defined in Sigma already, that's something that he has to take into consideration. And my question is that those people with parcels of land, and I'm not talking about developing land for large developments and subdivision. I'm talking about one piece of land that someone puts a house on and drill a well, they would by de facto become a de minimis user, as I see it. So you keep talking about pausing the decision on de minimis users. Is there a possibility that you can pause the decision on those landowners that don't have wells? Because that sort of falls into the category as well, and what's going to happen with them. And I'm not saying everyone's going to put a well on, or maybe one parcel will put it on and serve 2 others, but they would become a de minimis user. That's how I see it. So,
It's a good
thank
comment.
you.
I've been focusing on de minimis, but I hadn't thought about it in that context, so that's a good comment. Thank you.
Thank you.
Good evening. Thank you for the good job.
Thank you.
Could you state
My
your
name is
please?
Dottie Robinson. I am a regular homeowner. What I'm hearing tonight, there's a whole lot of well owners here. My question for you is tonight, was I supposed to be here, just a regular homeowner?
Do you receive water from the water district? Just when you say you're a regular homeowner, are you a water district customer?
Yes.
You received one of the mailers, not because you're a pumper, but because you're a landowner.
Yeah. I did receive a letter, yes.
Right. I'll say this, that if you own one house that's presently being served by the water district, the water district is in the lawsuit, and it will defend the rights that defend the water rights that the district uses to serve the customers.
So what does that mean? I'm supposed to be here tonight?
You can be here. I think you're asking whether or not you need to file the answer.
Right.
Do we say no? I'm reluctant to say it because we're not supposed to give you legal advice because we're representing the water district.
So what do you want me to do with the letter? Return it to you or return it to them or what?
No. Whether you file I'll say this, whether you file an answer or not, you will continue to receive water from the water district both before and after the final judgment. So I don't want the letter, but if you want to go home, you can. And if you do nothing, you'll continue to receive your water just like you have in the past.
What if I still continue to receive letters? What do you want me to do?
I'm not sure what other letters you're going to receive.
Okay, my question to you is, if I'm not going to respond to the letter because there's some stuff that I'm supposed to write, what do you want me to do if I'm not going to respond?
I don't think there is anything for you to do if you're not going to do something.
Oh, okay, good. So I'm free to go.
You are free to go.
Thank you.
Hi, Max Vasquez, reporter for News Review, and my boss wanted to ask about you quickly glossed over the redirecting or importing water from somewhere else. She wanted to know what you would mean by something like that.
Could you repeat the question, sir? I'm sorry, I didn't quite get it all.
Whether there's enough water or not, which my boss for News Review thinks there is. What if the decision would be like redirecting or importing from somewhere else to add to this and raise the prices of the water because of this kind of thing? How would you explain what the ramifications or consequences would be if you guys chose to import water from somewhere else?
I'm not sure I caught
if that's even a thing.
I'm not sure. I'm not sure that I caught your whole question. I do know that you're asking a question about imported water.
Yeah, if it turns out that there's not enough for, future and whatnot, and you guys decide maybe you should import water from somewhere else.
Well, if I may stop you right there, we talked about the replenishment fee that is charged by the Groundwater Authority, and the purpose of that replenishment fee is to collect monies to obtain imported water to bring into the basin to help address this water deficit that we have. So the GA has been and is actively looking for potential imported water supplies to bring in to the basin.
And what would the consequences be of that, like to the consumer and the landowners?
What would the consequences of bringing imported water be?
Yeah, in terms of prices, is the water bill going to go up like astronomically, like some places I've seen?
Well, the water district customers, you're already paying for the imported water, in terms of the replenishment fee. I can't speculate what would happen. That's based on a number of factors, where the water's coming from. All I can say is if we can get water into the basin, into this basin, it's a good thing. It will help stimulate growth and help address the water deficiency.
Okay.
That's all I have on that.
Thank you.
My name is April Kegwin, and I'm speaking on my own behalf this afternoon. I wasn't going to get up and speak until I heard you say, I believe her name was Dottie, that she needs to pursue her own legal counsel, which I find very interesting because as a district customer, I'm paying I believe $700,000 a year roughly was budgeted for your legal fees. That's on me as a district customer. So now I'm going to pay your fees, and my own litigation fees to have another party involved in this groundwater adjudication. Am I correct in that statement?
I'm not sure exactly what the statement was.
I am paying double litigation fees.
I advised Dottie that we represent the water district, and as such, we do not give legal advice to other persons. She asked me what I considered to be a legal question, and I couldn't answer it.
Okay. So, right, you represent the water district. We pay for your fees. So I would be paying twice. And again, just to piggyback, I believe, on what Mr. Heyman was saying, I've heard tonight that your goal is to bring certainty to water rights, but when I called your firm, I never got that as an answer. Instead, I was told it's to challenge you have issues with the GSP, which, just to remind everybody, the district did vote yes on. You actually seconded the motion to approve the GSP. Third, you also brought up the 7650 and that you're challenging that. Again, the district voted yes on that. I'm going to tie up my statements here by saying I almost find it a little insulting that our board members, who we vote in to represent us as the public and water district customers, is not sitting at this dais right now answering these questions. Instead, they're hiding behind attorneys. And no offense to any of you, because I really enjoy you all on a personal level. I just think you're voted in to represent us, and you're not doing that right now. You're sitting in the audience hiding, and I just don't respect that. I think I'm going to tie up my comments there. Thank you.
If I may respond, I'm aware of the conversation that April had with somebody at Doug's office. Her recollection of that conversation is not consistent with the attorney at Doug's office. It was never indicated that the purpose of the adjudication or the district is challenging the GSP or the $7,650, 7,650 acre feet. That's never been stated. It's never been the position. And my directors can speak for themselves, but just for the record, the reason they're sitting out here is because they wanted to attend this meeting. The questions that have been asked tonight and answered have been largely answered by Doug Everett, who is special counsel to the district to help with the adjudication. If you really want to know what to do with respect to the mailer and what the consequences are, do you want to listen to a seasoned attorney, or do you want to listen to your board? If you want to talk to the board about this issue or other issues, they meet every month, second Monday of every month, 6 p.m. They'll be willing to discuss this and any other issues with you. That's all I've got.
My name is Elliot Collins, Kern County resident. My first question would be, in your experience, would, let's say you have two different property owners, both de minimis users, pumping about the same amount. One of them chooses to answer back in the form, and the other person chooses not to. As they're both similar types of users, is there the potential that the person who did not answer back may have their water allocation be different than somebody who did choose to answer back and participate? Or are those allocations grouped together as like types of users, and all those types of users get allocated the same way?
I'm trying to remember how we dealt with that. You're talking about one well serving multiple parcels?
No. I'm talking about two completely separate properties, separate wells. Just one of them chose to participate and the other one didn't. But they're essentially the same type of user. Would the person who didn't participate, would their water allocation or their right to pump be different than the person who chose to participate, potentially?
I'll do my best to answer your question. I can't say for certain, but the goal is, if everything is equal, all things being equal, the goal would obviously be to treat those parties or pumpers the same. So if you have two pumpers that are pumping the exact same amount with the same issues, everything else being equal, the goal would be to treat them the same ultimately at the end of the day.
So the person who chose to participate isn't necessarily have a leg up on their neighbor who didn't choose to participate as far as how much water is allocated for them to be able to pump.
At the end of the day, I can't say exactly what will happen. I'm giving you my best estimate, but I would encourage anyone that does pump to actually file that answer, so there's no risk.
Right.
That'd be my recommendation.
Fair enough. I'm more like, in your experience, have you seen times where you have, this group of de minimis users is going to be able to pump this much, but these people, they showed up and they defended themselves and spoke up for themselves, they're going to get a little bit more because they fought for it?
If you're asking about my experience, at the end of the day, de minimis pumpers have historically been treated the same.
Fair enough.
And the goal is to treat them equally. And obviously there are some very large pumpers in this basin, and those are the entities and participants that are really going to have to address these issues and take into consideration the de minimis pumpers along the way. And I know I'm not directly answering your question, but the goal is to treat de minimis pumpers fairly, equally, but I would encourage anybody that's pumping to file an answer.
Fair enough.
Am I answering your question?
Yeah.
Okay.
So, and then another question I had was, in case of the event that the vast majority of residential pumpers didn't file an answer form and they were vastly underrepresented, and end up getting allocated, significantly less than maybe what they are already pumping or whatever, with the water district spearheading this effort, would the water district be seeking to try to gain some of those acre feet that would be unallotted because they were unrepresented by other users?
Do you want to answer that, or do you want me to? I think we'll go ahead, Jim.
I only ask because in the mailer, it's alluded to the notion that the water district's claim to the water supersedes anybody else's because they serve the community, their customers.
You want me? I'll go ahead. The public municipal, there's a hierarchy in water rights as to priorities as to what's the most important, and serving people is the highest priority. And that doesn't matter whether it's the water district or anybody else. If it's for the people, for municipal use, that's the highest priority. And the goal is to treat them equally. I said this a couple times already, but I do encourage any pumpers to file an answer and stay actively on the district's website for information, because we're no action will be taken by the court without advance notice to everybody what's being considered or thought about. And our goal is to be as transparent, be fully transparent, and get information out there so there's no misunderstanding or miscommunication or misinformation that's out there.
Okay. And then you mentioned that, typically there's some sort of a water master, an agency or entity put in charge of the basin after these judgments. In other judgments, has it been the case where one of the parties of that lawsuit is named as the water master?
That is one of the most hotly debated issues in these cases as to who's ultimately the water master. I shouldn't say hotly, but mostly discussed. I've seen some basins where it's an engineer and an engineering firm that's the water master. In the Mojave, it's the Mojave Water Agency, which is the importer of water. It's a water district existing that was involved in that case. In the Antelope Valley, it's a 5-member board consisting of both municipal and landowner interests. So it's a function of what the parties come together and agree should be the best solution. It could be one of a number of different things.
Is it possible for one of the parties of the lawsuit to be named as the water master, or is that considered a conflict of interest?
That's a possibility.
Okay. Thank you. That's all I have.
Mm-hmm.
Hi, my name is Pat Blubaugh. I have 3 easy, quick questions, and I'm serious. First one, last date to file is?
60 days after receipt, it would be in the notice.
60 days after receipt, when you actually signed for
Yes.
the document at the
Yes.
post office? You are not, if I'm correct, you are not required to have counsel to file, correct?
You're
so
correct.
the individual can file.
Correct.
Right now it's $1,000 for the first 18.
Yes.
And hopefully that'll get waived, but we're not there yet.
Yes.
And 3, once everyone files, then it's recommended that we then group together and find counsel to represent us in like kind. I know you can't give advice, but I think that's what I heard throughout this evening. True or false?
And that's one of these things where I'm going to give a little bit of a longer answer on that one, is that we want to see in the short term to what extent the de minimis pumpers need to participate in this case. But assuming they do, we'll obviously have a lot of communication with de minimis pumpers. The fewer people that actually, if there are people that can be a spearhead person or persons on behalf of the small de minimis pumpers, that would be wonderful. It's just a lot easier to communicate with a smaller number of people than it is, hundreds, obviously.
Sure.
And if we need to cross that bridge, or if the de minimis pumpers need to cross the bridge about representation, we can have that discussion.
Okay. Thank you.
Mm-hmm.
Sir, could you repeat your name, please?
Pat Blubaugh.
Thank you.
My name is Ernest Bell, Sr. I arrived in Ridgecrest in 1943. We didn't have a water shortage then. I've watched the town grow and the county grow, and growers come and go, and now we're in trouble. I have some questions. One of the questions that was first became aware to me here was in this notice, this $1,000 fee when you sign up. I have 4 parcels. Do I have to register each one independently, or does one waivered $1,000 cover all 4?
If you're hopefully we're going to get it resolved so you don't have to pay anything.
I'm sorry, I have a hearing problem.
Hopefully we're going to get this resolved so you don't have to pay anything.
That was my next question.
Yeah.
I saw where you've asked for it to be waived.
Yeah,
when do you expect an answer on that?
The current hearing date is in early April, but we are going to go to court hopefully here in the next week or two to see if the judge will take up that issue sooner. And please keep an eye on the district's website because we intend to post information as to how that process is proceeding.
In other words, it's not going to be resolved before that March 15th meeting in Orange County?
We hope to have it resolved before that date.
Okay, I have, excuse me, a couple of questions earlier. And if I ask a question that has already been answered, I'll apologize, but I have a hearing problem. And the audio is not too good anywhere in here. You mentioned, lady mentioned property that is unimproved, but it has overlying water rights. I have some property here. I've got 4 parcels. 2 of them have wells, and 2 of them are vacant. But they all have, I bought that property 50 years ago, and to my knowledge, it does have overlying water rights. Now, is part of the settlement on some of this, and you mentioned water rights sales. Is that something that is possible in this judgment where a piece of unimproved water or unimproved property that has water rights, they're going to be able to sell the water rights?
Yeah, at the end of the day, I don't know how that's going to play out if there's not current pumping. Historically, what we've seen, for example, in the other basins is that the water rights that were that could be sold were pre-existing pumping. How the court may address a parcel of land that there has not been prior pumping on, I don't know at this particular point in time.
Okay. Because it was mentioned earlier, if you get an adjudication here where the water rights are either removed because they talked about putting a moratorium on wells, that if they put a moratorium on wells, and that was mentioned in the certified letter that you sent out.
In the language that was included in those letters was required by the statutes that we're filing this lawsuit under. I want to be clear about that, and I apologize I didn't mention that earlier, but the language that you're seeing in these letters and the forms that are in these letters, those are required by the comprehensive adjudication statute. It wasn't something that Jim or I did unilaterally, but the law requires that we send out those forms in that way. So to the extent there's language in those documents that came right out of the statute, but I think I tried to be clear earlier as to what the water district's goals are in this particular case.
Okay, well, that was mentioned in that certified letter that a moratorium could be put on wells, either stopped from the county or a permanent moratorium. That wasn't explained. I wasn't sure of that because the property that I have is grown considerably in value, and if all of a sudden the water disappears, it's worthless, and that was mentioned by Peggy Braden. Is there a possibility that that can happen in this adjudication?
Yeah, I don't want to speculate about the future, but that's why it's important to participate if you do have wells. And again, the language that was in that letter that came out was we had to put that letter. The water district had to put that language in that letter.
Well, that comment disturbed me pretty much.
I understand.
Yeah.
Hopefully, we're clarifying some things this evening for you.
The other issue, and maybe it's not directly related at the adjudication, but the Groundwater Authority people and you folks have seen where there's some conflicts there, one of them being where the funding is going. Is that being addressed?
We're trying. The water district is meeting with not only the city but the county also at various times to discuss the issues that are facing the GA and the water issues that we're talking about tonight. We don't always agree with them on everything. They don't always agree with us. But we are trying. We are meeting, and progress is slow, but it is moving.
And the other thing that disturbs me was when there's conflicts going on, and you folks, your representative on that board was put on the bench. Is that a settled issue, or you guys working on it?
Are you referring to the fact that the Water District is not the chair of the GA this year? Is that your question?
My speculation is like I think they put $2,100 on an acre foot of water in that neighborhood. Is that correct? Is that the value?
The Groundwater Authority has imposed a replenishment fee in the amount of $2,130. And that replenishment fee applies to any pumping that is done over the safe yield, 7,650 acre feet. That 7,650 acre feet has been allocated may not be, but it's been distributed to the domestic pumpers, Searles Valley, like I talked about earlier. I lost my thought. Give me your question one more time, sir.
Pardon me?
Your question one more time. I'm sorry. I'm hard of hearing as well.
Well, you have my sympathy.
Okay, here you go. So I got you, sir. We were talking about the replenishment fee. So any pumping over the 7,650 acre foot, which is the safe yield number contained in the groundwater sustainability plan, is subject to the replenishment fee. And so anybody, Searles Valley and Mojave Pistachios are the easiest examples. They're both large pumpers. They were not allocated any portion of that 7,650 acre feet. So all of their pumping is subject to that fee. And then that fee is collected, well, the Water District is presently the only entity paying that fee, but we collect it and we pay it directly to the Groundwater Authority, which should be used for the acquisition of imported water.
Well, I guess I'm also a little disturbed that you folks are kind of in a position where you've got more experience on the water, but those folks are calling the shots on where we're going out of the valley to get it, and the whole financial puzzle that's trying to be put together. I think they're making a mistake by setting you folks on the edge. And I don't know what you can do about it, but keep trying.
Yeah, I know. All I can say is, things have happened. We're trying to move forward, and we're talking with the county and the city about a number of different issues.
Okay. I have one more question. If you're trying to respond to the court stuff in Orange County on your parcels of land, is there a instructional check sheet that you have that tells what kind of information is important to put in your presentation?
Yes, there's one of the forms that you should have received is called an answer to the complaint or cross complaint. It's a couple pages. But what we're going to do is put on the district website here in the next couple days specific instructions on how to do that filing, and we'll include that form as well with specific instructions on how to do that. So just take a look at the district website and click on the tab that says Basin Adjudication.
Okay, so there will be a sheet available that you can fill out.
Yes.
Water estimates. And
you won't need to provide your water estimates yet. It's just basic information, your name, address, contact information, and the location of the property.
Okay, and I apologize, I got one more question. Now, were you involved in the Antelope Valley adjudication?
Yes.
Okay, to your knowledge, now you have 4,000 or 5,000 homes down there, and they vary from 1,200 square feet to 4,000 square feet. In the adjudication process,
was the size of the home compared to the allocation of water that was given to those residences, or was there an average value used for all the residents?
I think the best way to answer your question is most homes in the Antelope Valley are receiving water either from a public agency or a mutual water company, if they're, when you say a group of homes. And those public agencies and mutual water companies were allocated a certain amount of water that they could receive and pump for free. And then if there was pumping above what they were allocated, they had to pay X amount of dollars to fund acquiring additional water sources that became available. In the case of de minimis pumpers, they were allowed to effectively keep pumping it up to a certain amount without certain fees and charges.
Well, I know, like in our valley here, there's tier levels to it. And you go up the tier levels till you can't afford how much it costs a gallon. So I don't know whether they're going to do that or not.
Well, in this particular case, for example, if you're receiving water from the water district, you'll continue to do so. And how those rates work specifically, others would have to speak to that.
I fit in both categories. One of my houses, I have a well, it's an agricultural well, but I also have city water.
Okay.
Thanks for your time.
Thank you.
Elliot Collins again. Sorry, two more things that I forgot about. One of those is, have you ever seen a scenario where during one of these adjudications the judge requires that further surveying be done on the basin before a decision could be come to?
When you say surveying, you're talking about analysis of water availability? Oh, yes.
Yes.
I expect that to occur. It is occurring, and I expect that to occur through this case. Experts will opine as to what the sustainable yield of the basin is. They'll look at the storage. So that process will likely play out here.
So it wouldn't necessarily all be based on previously acquired data?
You're correct.
Okay. And then the other thing...
It may, but it may not.
Right.
Right.
Sorry, I lost my train of thought.
I interrupted. I'm sorry.
So if I'm understanding correctly, the comprehensive adjudication is kind of a end-all, be-all final type decision. That being the case, would a judgment in this that conflicts any of the other ongoing litigation nullify those other ongoing litigations over the water basin?
That's a heck of a...
Or void can just stop them in their tracks?
That's a heck of a question. I don't want to opine as to what may or may not happen in the lawsuits that are pending with respect to the challenge to the GSP and the Groundwater Authority. But what ultimately will come out of this lawsuit at the end of the day, as I mentioned before, will be reviewed by DWR, will be harmonized with, in some form with the GSP, and will bring finality at the end of the day. I can't really speak to what may occur in those other lawsuits, but the goal here is to bring finality permanently for everything.
But would the judgment on the comprehensive adjudication take precedent over any other judgments? If in any of those cases a judgment has been come to before the judgment in the comprehensive adjudication, would this supersede that judgment?
It sounds like a law school exam that I had once. No, that's a good question. I'm joking. Would it supersede? At the end of the day, I'm trying to be careful with my words here, that it can't override other judgments. At the end of the day, it's possible that there could be. I don't want to go there. There could be situations where the lawsuits against the GA and the GSP are resolved, and ultimately at the end of the day, this particular adjudication is the final say. This is the only lawsuit, and also with the cross-complaint by Searles Valley and the water rights case brought by Mojave Pistachios. These are the only cases that address water rights. So water rights will be addressed, and these are the only cases that will involve the Navy. So I envision that this case and all these water rights cases under this umbrella will bring finality. And at the end of the day, there has to be some form of resolution to the GA lawsuits. What that resolution ultimately looks like, I don't know, but it'll somehow get merged with what we're doing here.
Fair enough. Thank you.
Well, Michael Palmerin, de minimis well user over in Ridgecrest. So I'm not sure if I heard incorrectly, but you guys were saying that you spent $4 million for water reacquisition, and it's supposed to be used for water reacquisition. I don't think I heard you say that it is being used for water reacquisition, and that they're going to be looking into where to get water from. Am I mistaken?
What I've talked about is, again, there is a replenishment fee within this valley. And the purpose of the replenishment fee is to acquire imported water. Mm-hmm. The thought being is that you got to have the money before you can buy the water. So the GA is taking the task that they're acquiring the water through the replenishment fee. Should be stockpiling that. I know they're using it. There's other actions that need to be taken that might be related to the acquisition of imported water, but actually isn't giving them the money. There are actions being taken along those lines to identify, contact potential sellers of water.
Okay.
And then for the water district, about just over 2,000 acre feet, or about 2,000 acre feet of the water district annual pumping is subject to the replenishment fee. So this year, we've collected over $4 million on behalf of the GA's replenishment fee and passed it on to the GA.
So you don't necessarily know if the replenishment fee is actually going to solve the problem. You're just stocking up on the money to use it to find services, but then in the end, it might not even actually solve the issue. I'm sorry, I just don't.
That's okay. It's all fair. But the replenishment fee, it's a groundwater authority fee, right. And we're the water district. We just collect the fee and pass it on to them. So I don't think it'd be appropriate for me to necessarily speak on behalf of the GA with respect to that. They're collecting money, and it's supposed to go for the acquisition of imported water. I will say that if you read the groundwater sustainability plan, and I think very few people would disagree, that we do have a water supply deficit. There's way more water demand than there is supply, and the imported water is supposed to be one tool that this valley is going to use to bring it into sustainability. Nobody thinks that there's enough water out there for everybody to pump forever.
Right, and so, I mean, my house, bought it 3 years ago, but it was built in 2005, and I noticed a huge hotel built in the past year or so, and that probably uses a heck of a lot more water than I would use. But aside from that, I'm just wondering, so the replenishment fee, they would probably be paying more, and the supposed casino that people wanted built would also be using more water, to the point that they would be paying more for the replenishment fee, which would potentially solve the issue of water coming in and we wouldn't have a water deficit?
I think it's, I don't know if you should look at imported water as the final solution for this basin. It certainly can be one tool that could be utilized, but in terms of bringing new water into the basin above this 7,650 acre foot number, I would point you to an easier source, and that is recycled water, which is already here within the basin. We don't have to construct a 50-mile pipeline or anywhere like that. There's 2,000 acre feet. That helps to close the deficit between the two. whatever imported water the GA is able to acquire further closes that gap that we're trying to close so we can reach sustainability as defined by Sigma.
Okay.
And the last thing you talked about, the hotel and everything. The way the fee is charged, it's charged unilaterally across the district customers. So the more water you use, the more replenishment fee you pay.
Okay, so the more water that hotel or those businesses use, the more everybody else pays.
No, they pay as well.
Okay.
Anybody that is using and receiving district water is paying their fair share of the replenishment.
Okay, so sorry, I was thinking the
No problem.
wrong terminology. Okay, thank you.
Hello, I'm Kelly Cutts, and I'm a de minimis user on Inyokern. And there was a gentleman that asked a really question that I was interested in hearing the answer to, but I don't think I heard it. He said, if you have more than one parcel of land and you file a response to the suit, is the filing fee until it's waived per parcel or per landowner?
Usually it's per party, so if you're the same owner, it should be one fee or one fee per person. Is that the best way to describe it, or per entity?
Okay, so
Doug, I think what they're asking is, and it was actually Mr. Bell's question, is he owns those 4 parcels. Can he file one answer on behalf of those 4 parcels and thereby only be subject to the $1,000 filing fee? I believe that's your question.
Yes,
Yeah,
that's
I'm
my
sorry.
question.
My bad. Yes, just make sure you identify all the parcels.
Okay, so, that's the answer to one question. And my other question is, there's been a lot of conversation about the replenishment fee and how that fee was analyzed and created, but I haven't really heard about what about getting the water here. We understand what it costs to pay for the water we're going to buy to replenish, but how are we going to get it here?
Well, there's two ways. Both of them are difficult, and they're being looked at. One would be to somehow tap into the LADWP aqueduct to the west, and then the other one would be to build a pipeline, presumably from California City, which is where AVEC water terminates. Those are the only 2 potential avenues to bring water into the basin that we're presently aware of.
So could the replenishment fees go up then once that decision is made in terms of, pipelines cost money?
I'm not going to speculate on what the replenishment fees may or may not do. And I only say that because it's a groundwater authority fee, and what happens could be dependent upon a lot of things. Just like it's possible the replenishment fee could go up, there could be circumstances that come up where the replenishment fee goes down. So it can go either way. There's so many factors that come into play right now. It's very hard to give definitive answers to what may or may not happen.
Okay.
So I'm not trying to dodge it.
Okay, thank you.
Okay, do we have anybody else that's in the chamber that has a question or comment? If not, I think we have some people on the phone that, okay.
Hi, my name's Chuck Griffin. I'm speaking for myself tonight, not as a board member. I just want to thank the public for coming out tonight and everybody getting involved. But secondly, please attend your meetings and go to the water board meeting, go to city council. And as a public person, I would like to see the water district and the city have a joint meeting to where we could ask questions and answers and get answers back. Thank you.
You answered a question earlier where you said that the water district passes on the replenishment fee unilaterally across all customers. Does the water district have any plans, or has it looked in the past at the potential of passing along the replenishment fee at a varying rate depending on the type of user, such as residential users who use their water because it's a basic necessity, getting charged at a different rate than businesses who make money off of their water use?
We do pass it on equally amongst all customers. I will say that, the district is starting to talk about doing an additional rate study. And I think when we do a rate study, that we'll look at all potential options and what possibilities we have, including, how we can charge the replenishment fee in a fair and equitable manner. So we probably will look at that. We haven't done that actively right now. We've been paying it for about 1 year, and this is easily the most equitable, just straight across. But that doesn't mean, like anything else, that it cannot be that it can't change.
Fair enough. Thank you.
Evening. I'm Mallory Boyd, speaking for myself. I was listening to the questions and I was hoping this would come up, and it didn't, so I'll bring it up. The only date that we have on these letters is what was printed on the letters themselves. The dates that I've received, 2 of these have been completely different dates. One was just 6 days ago. What date do I start? And I didn't sign for either of these letters. And I think a lot of folks here in the room probably didn't either. So when you say 60 days, it's a legal timeline, right? So what clock are you using to start the 60 days?
That's a fair question. The mailers in a perfect world would have all gone out at the same time. There was an outside company, as you know, that was retained to do this. There were some issues with paper supplies. I didn't know that was part of the supply issues, so they went out at different times over the holidays. My advice would be to file the answer. What we're required to put in those letters by notice is 60 days after receipt, so I understand that it's not perfectly clear as to what 60 days would apply. What I will say is that, I think I can say this on behalf of the district, is that we're not going to take any immediate adverse actions if people are not filing, if they have some confusion as to which day applies. A lot's going to be happening. I shouldn't say a lot. Things that will be happening in the short term are just procedural issues with the court on next steps. So my advice would be to, just maybe to everybody, is to err on the side of caution. But if there's any concern about what may or may not happen with respect to the timing of the filing of an answer, please shoot us an email and we'll get back to you and make sure you're taken care of.
Okay. And of course, the obvious not asked question is, with this filing fee, since we don't know if it's going to persist or not, folks will want to delay filing their letters until they know if the fee is going to be real or not. And that 60 days comes into play, because 60 days could get me all the way to March 15th.
Right, and that's why we're going to court. We file the paperwork at the court, and they automatically set hearing dates just upon court availability, but there's a process we can pursue to go to court on what I'll call an emergency or urgency basis to request an early hearing date. That's what we intend to do. So we hope to have final resolution on that ASAP well before that 60 days runs. And maybe I'll start encouraging, maybe I'll take a quick look as well as to who has filed and how many more we need to get to that 18. And if we need some of the larger pumpers to file right away and get to that 18, I can work on that as well.
Okay, thank you. And I have one final question. I've taken questions from the public that I didn't have answers for, and I know you guys have cautioned me about answering these questions, so I thought I'd ask you so that you could ask or answer it for the public. I know a number of folks who have small mutuals, 4 people on the mutual, and of course each of those property owners on the mutual receive the letter. Some of these mutuals are filed by a a mutual name and not the individuals that are on the mutual. So do each of the mutual participants have to file, or can the mutual itself respond to this drill and have those 4 people represented, or 8 people?
That's a good question. I think my partner Emily, who you may have met before or spoken with before, is looking into that. And I believe that we either have or are answering that question on the FAQ that's posted on the district website.
Okay.
My default is everybody should file, but I'm not 100% sure that's correct, but I'll make sure I get a positive answer and we'll post that.
All right. Thanks, guys.
Okay, one more time. Anybody have a comment? I know looks like there's people that have been on the line and have been patient, so I want to open up the phones if possible. So one more time. Anybody? Seeing none? Okay. Do we have somebody on the phone? Caller, state your name, please. Caller, state your name. Hello? Hello? I see a green light, but nobody's responding. Are you on mute, possibly? One more time. Hello?
Yes?
Yes. Caller, go ahead. State your name, please.
Yeah, this is Wes Katzenstein.
Okay.
You hear me just fine?
Yes, we can hear you, Wes. Go ahead.
Yeah, a couple questions. First of all, I'm concerned that there's going to be some magical agreement between all the players. If there were going to be one, we would have found it by now. And the other side of the coin, if we end up taking everybody's baby and cutting off 80% of it, you leave everybody with 20% of their baby, I don't think it's going to work for anybody. So I think there's going to have to be some tough questions, some tough decisions made. And I kind of have, my first question is, you know, if you look at the challenge that was placed before the Groundwater Authority and the legal constraints, very challenging. And you look at the Constitution, you know, there's you have to make reasonable use of water, you have to not waste water. It says there's a human right to water. It says that residential use is more important, is the first most important use of water in the state. Agriculture, the second most. Doesn't say anything about industrial. And so it's a really tough set of conditions, and yet the Groundwater Authority came up with what I think is not a bad solution given the challenge. I understand why you guys are involved in this lawsuit, because you almost have to given all the other lawsuits. But my first question is the judge in this adjudication going to really reside by the same set of legal guidelines that has driven the Groundwater Authority? Does the judge have to satisfy all the same legal requirements, or does he have some greater powers, say, than the Groundwater Authority?
I think the best way to answer that question is that there are different issues initially at stake in the adjudication case. For example, we are determining water rights, and number two, that the Navy will be involved in this case, as I've mentioned earlier. At the end of the day, whatever settlement and resolution is proposed will be publicly vetted through the court system, and we'll try to do it through a variety of means, but everybody will have a say in that. I'm not sure I'm directly answering your question, but the judge will have to follow the laws applicable to water rights and the priority of water rights that you mentioned as well.
It's my understanding that once the judgment is, once there's a final judgment, it would be submitted to DWR, and that judgment does, in fact, have to comply with the requirements of SGMA. So the judge is, I'm not going to say it's exactly the same, but the judge, as I understand it, will be largely bound by some of the same criteria used in SGMA.
So what I think I hear you saying is that maybe the judge can't take away water rights, but it can prioritize water rights. Is that right?
Yes, based upon applicable law.
Okay. And then the other question I have is what the technical basis for the adjudication. You know, there's been a very strong and I think technically excellent effort go on here to determine the 7650 and the current pumping, and to try to get our arms around all the areas of bad water in the basin and that are encroaching on the good water. And I think that's a very sound technical foundation. Yet I kind of think I heard you guys say that the technical, it might be a first flyer doesn't stand a chance kind of a thing when it comes to what the technical foundation that ends up being used in the adjudication. I think that's a threat to the basin, and I worry. So my question is, what if you have a bunch of paid experts that are representing their clients, you know, how do you wade through all that and come up with a good technical basis for the decisions you're going to make?
Well, the good question. The way things have been resolved in prior cases is usually when good, solid experts, engineers, hydrologists, et cetera, get together and they have the appropriate data. The goal, obviously, is to reach agreement and consensus. Part of the process is making sure that everybody's dealing with the same data points and information. I know the district has been aggressive on some of the modeling and investigation that they're doing. So to answer your question, the goal obviously would be to have the most information and most current information available that can be reviewed by everybody and hopefully reach agreement. If not, then that's up to the parties to present the competing views to the court and the judge to let him decide what's most appropriate, obviously with the goal in mind of doing what's best for the basin and the community.
So that sounds a tad bit risky because you're asking the judge then ultimately to make the technical decision.
That's why we're frequently motivated to try to resolve it without having the judge do so, and that will be the goal here.
Okay. And my final question is, it seems like California law is kind of allowing almost two parallel solutions here, even though we talk about harmonizing the Groundwater Authority with adjudication, and you talk about we're going to talk as if the replenishment fee is going to continue and we're going to import water, we're going to continue in that effort. But on the other hand, this adjudication could come down in such a way that it completely pulls the rug out from underneath the Groundwater Authority. That basically the prioritization of water rights and the approach is taken becomes invalid. And so I'm a little bit nervous that we really, somehow California law is, in a sense, entertaining two parallel approaches to solve this problem. It seems like that's not a good way to run the state. But I guess, are you comfortable that they can be harmonized, or is the Groundwater Authority just out of luck?
Well, I'm not going to comment on that's not a good way to run the state, and I'm saying that jokingly. This is one of the first cases that deals with both an adjudication and groundwater sustainability plan, and you raised some very astute points. And the law is not clear on how both the adjudication and the GSP will in fact be harmonized, other than we're required to do it. But you raise good points, and those are outstanding issues that will need to be resolved, and they haven't been to date in other matters.
Okay. So I really hear you saying they do play by the same sort of legal ground rules, and let's see where it heads.
Yep. Yes.
Well, thank you guys for your efforts. I appreciate it, and I understand why you have to do this. Hopefully it's the final decision. It would be really nice if you guys could prioritize the water rights, and the GA could manage it using the structure they come up with to try to import water and solve the problem. Anyway, thank you guys so much.
Thank you.
Have a good day.
Okay, it looks like we have another caller in the queue. Caller, thank you for your patience.
Thank you.
Please state your name.
Thank you. Mike Sanat.
One more time, please.
Mike Sanat.
Okay, go ahead, Mr. Sanat.
Hello?
Yes, we can hear you. Go ahead.
Okay. First thing I'd like to say is to thank the Water District. I'm very glad that they filed the adjudication. It should be obvious to most people that they represent the interests of property owners and water rights, and their alignment would be naturally with the well owners. My concern, my biggest concern on this has been the Navy, and I'm glad the Navy's been brought into this action. I'm most concerned with their assertion of Federal Reserve water rights, which is essentially codified in SGMA under the section 107.20.3. And that assertion is based on a doctrine which has, from my understanding, never been adjudicated on a federal level. It's questionable whether the Department of Defense has the authority to make this assertion of Federal Reserve water rights. And the problem is that in doing so, in this case, the Navy is essentially setting precedent, and I don't believe the Lancaster Edwards Air Force Base adjudication is necessarily a good case foundation for the Navy's assertion of Federal Reserve water rights. I don't believe the court actually had the question or the authority to make a decision on whether the Navy's assertion was valid. But the problem I have is that this assertion effectively gives the military Federal Reserve water rights precedent on 16 million acres of Bureau of Land Management public lands that are withdrawn temporarily by the military. In the case of China Lake, 1.1 million acres of land that's Federal Reserve, or that's BLM land, is now held by the Navy temporarily under the law of reservations from BLM lands. So it's not like Edwards, which was owned land. Plant 42 is owned land by the Department of Defense. It wasn't BLM public lands temporarily withdrawn. So that is one of the big issues I have, and my question to you would be whether or not that assertion by the Navy will be accepted, I guess at face, or would the court consider downgrading their priority to beneficial use, or would the Navy withdraw their assertion? Could you see that potentially being a part of this case? In other words, the assertion of Federal Reserve water rights is withdrawn by the Navy. They accept a beneficial use status, and that eliminates this idea of rolling over unused allocation, which is 7650, but they're only using 1450. Thank you for trying to answer that question. I know it's a little bit complicated, but I do appreciate the Water District's efforts, and thank you.
No, I appreciate the question. I'm not going to speculate what the government may or may not do with respect to its claims, but it will be required to, the federal government and Navy will be required to prove up their water right in court, unless the parties otherwise agree to it. But the judge will receive evidence from the federal government regarding their water right, and the judge will consider any parties who have arguments or positions contrary to what the federal government may say with respect to their water rights, and then based upon the evidence that's before the court, the judge will decide the nature and extent to whatever rights the federal government may have. But ultimately, it's the judge's decision, but the Navy has to prove their rights, and parties are free to contest it.
Well, I hope the Water District will do so, and again, I thank you very much.
Thank you, Mr. Sanat. Okay, we have another caller. Caller, thank you for your patience. You're live. Please state your name.
Good evening, gentlemen. This is Elaine Mead. I'd like to talk to Doug for a minute. I understood him to say that as a property owner that hasn't exercised their water right yet, that you would probably need to go before a water master to get permission to drill a well. Am I correct in that?
I got way ahead of where the court may go. I did say that, but I got way ahead. I was just speculating what a court may do, but I don't know. I only was articulating what I've seen in other jurisdictions. So what the court may or may not do in the future, I really don't know as to what may occur with property owners that do not have an existing well and the process and procedures that may be put in place to drill a well at a future date. That's why I would encourage everyone to keep a close eye on what's occurring here. We do intend to make all the information public as soon as it becomes available to us. And as I think I mentioned earlier, we're going to do our best to provide information that to the public so all court filings can be reviewed as well.
Okay, now for my question. That being the case, then would a new water district hookup need to get the same permission from the water master? And if not, why not?
You want to go ahead, Jim?
I'll try. I don't believe so. I think that what will happen is the water district will be allocated a certain amount of its water right, and then as new connections come, it's what we're doing right now. They're just paying their fair share of the replenishment fee, and I think that would continue to happen.
Okay. So if what I'm hearing is correct, you are saying that there's no growth potential for unexercised rights, but there is if you live within the district?
You want me to take that one? Yeah, I think if I understood the question correctly, the water district will continue to provide water to its current and future customers as it has historically, subject to whatever judgment and allocation comes out of the physical solution. How it'll play out to parties or property owners that do not have current wells and where and how they'll get water in the future, that'll be decided through the court process, and that's why it's important for people to participate if they want to have a voice in that.
Okay, thank you very much. I appreciate it.
Thank you. Okay, we have another call. Caller, thank you for your patience. You're on. Please state your name. Hello? Caller, are you on?
Yes.
Please state your name.
Yes, this is Renee Westolusk, and I have a few questions. My first one has to do with small mutual. The current allocation from the 7650 that's been allocated to small mutuals is 322 acre feet a year. Now, those small mutuals, how do they get representation in this adjudication, because a lot of them pump more than the 2 acre-feet a year, and they don't qualify as de minimis water users. So would they, if they file and answer, any of the owners of these private wells, will they be exempt from the $1,000 filing fee, or will they have to pay that because they're not de minimis water users? That's my first question.
As I mentioned earlier, our plan, we will be going to court here in the immediate future to seek a waiver of the filing fee, and only the first 18 parties have to pay that filing fee, even if there were not an exemption. But the intent is to get a waiver of that filing fee. We should have that information shortly, and we will post it on the district's website as soon as we have more information. On the issue of representation, that's the subject that we'll need to address going forward. I've talked about that briefly. In the case of mutual water companies and some of the larger ones, what I saw in both the Mojave and the Antelope Valley was many of the mutuals got together as groups and retained a single lawyer to represent their collective interests, and that worked out quite well.
Okay, because I have another question that is adjoined to that, and that is one of those private wells that's listed under the small mutuals happens to be a private well owned by a homeowners association. And they were put in that group. So they're technically not a mutual, but they were allotted water from that allocation of the 322 acre-feet a year from the 2021 allotment sustainable yield schedule. What I want to know is how, if they don't belong to a group, they'll have to get their own legal representation?
I don't know the specifics of what you're describing, but in the adjudication, parties are free to participate without legal representation or with legal representation. And as I mentioned before, just conceptually, it's worked well when groups come together, and if they want counsel, they hire a single attorney to represent their interests. How that may play out here, I don't know. And what I should also add, I didn't mention this earlier, if there are very specific questions as to particular parcels that you have, please feel free to shoot us an email. We've been getting quite a few recently, and we do our best to respond to those timely, but happy to do our best and happy to respond to the best that we can.
Okay, and then I have like 3 more questions. How many years did it take to settle the Antelope Valley adjudication, and how many years did it take to do the Mojave River adjudication?
Good question. The Mojave case moved along rather quickly. I put quickly in quotes. Once we got all the parties served and the parties sat down to start working on a physical solution, it's been a while, but I want to say a year and a half, maybe 2, before we had something that was really concrete that we could present. That case moved along as far as water rights cases go, pretty quickly, and it went, with the exception of just a very few parties, very amicably. What happened in the Antelope Valley, and I won't get too wonky on the legal side, but that case was initiated prior to the comprehensive adjudication statute, which allowed what the district is doing here to serve notice on everybody to bring in the federal government. That statutory scheme wasn't in place, so something unique was done there to involve the federal government, and that was establish the 2 separate classes that represented the non-pumpers and the small pumpers. And I would say just that process alone, for a variety of reasons, slowed it down, 5-6 years or so. And there were a lot of fits and starts. And another thing that caused that case to take somewhat longer than it did is the case was initiated by some agricultural interests in the Antelope Valley, much like we have here where Mojave Pistachios filed a lawsuit. But it was maybe 5 years, I believe, I may have that wrong, but I think roughly 5 years before the overall adjudication was filed. So between the class actions and the 5 years that it took to turn the case into a comprehensive adjudication, that case took a long period of time. Ultimately, it went up both through the trial court and the appellate courts and was recently resolved this year, finally. Or should I say last year.
Okay, and then do you know what...
Yeah, I'm sorry, I just want to maybe one little add here is
Okay.
that because this basin is confined, it's smaller, fewer parties, I would envision this, once we get procedural mechanisms in place here in the near future, that we can start having substantive discussions very soon. And the goal would be here to move this case along quickly and try to reach resolution much sooner than later.
And then I wanted to know about the costs. What did the Mojave River adjudication cost in legal fees?
I don't know the answer to that. I would have to go back and probably the same answer with respect to the Antelope Valley. What I can say is it's always nice to poke the lawyers, which I'm fine with that. But there are a number of lawsuits that are currently pending that would occur and continue to occur with or without what the Water District is doing now. So the Water District is in this regardless, and the Water District's doing its best now to take the lead and get it all resolved.
And then my last question has to do with the 7650 natural recharge, of which the Navy has laid claim for their total Federal Reserve rights. And there was, like I spoke about the allocation for the small mutuals, but there was a chart with allocations for all the domestic water users in the valley. By challenging that 7650 Federal Reserve right, isn't there a big risk that the Water District's going to end up with a smaller allocation than what they already have, which is currently from 2021, 4489 acre feet a year? And if that happens, if they lose some of that, say half of it, that means this valley is going to have to import more water to make up for the loss from the Water District. And then that's going to cost more for all the Water District customers. We're going to have to pay a lot more because right now it's set that the Groundwater Authority was looking at purchasing up to 5 acre feet a year to bring up that 7650 up to close to 12,000 acre feet a year, which would be enough water supposedly to meet all the domestic needs of this valley. And if this adjudication takes away some of what the Water District gets, then the Water District customers are going to have to pay a lot more over the years for water because they'll have to import more.
There are a variety of things that may or may not occur in this adjudication. There could be recycled water. Farmers could agree to sell and or fallow their land. Imported water, perhaps the federal government will contribute to infrastructure costs. So there are a variety of things that can be done proactively to resolve issues. And whether the Water District's right is X or Y, the bigger issue, not the bigger issue, but an issue is, okay, fine, but what are we going to do to solve the long-term problem and bring finality to this? And that involves a whole host of solutions that can be driven by a variety of financial factors that I just mentioned. So at the end of the day, we've got a lot of people that will be involved in this process. A lot of people will be adding their 2 cents, and we've got some good experts from representing competing interests in all this. And when I say competing interests, different types of producers that I'm confident will bring a solution here that'll be good for the valley.
But will it be good for the Water District customers?
Well, I'm the Water District's attorney, so I'm going to do my best to make that happen.
Are you going to assure us that you're going to try to fight for at least the allocation we have so we don't lose that? amount?
I'm going to do my best I can for the water district, but again, the water district's a public agency, and I'm sure my board wants me to do what's right for the public.
Because I am a water district customer. I don't want to have to pay more because somebody else got part of our allocation.
Understood.
Okay, that ends my questions. Thank you for listening.
Thank you, Renee.
Okay, that ends my questions. Thank you for listening.
Thank you, Renee.
Okay, that ends my questions. Thank you for listening.
Thank you, Renee.
There's a new caller? I'm sorry. Okay.
Hello?
Hello, caller. You're on. Thank you for your patience. Could you state your name, please?
Yeah, they're still running her. Hello?
Yes, we can hear you. Go ahead, please. State your name.
My name is Mary Lundstrom.
Okay, Mary.
And running her. I know.
Hello? Yes, we can hear you. Go ahead, please. State your name.
My name is Mary Lundstrom. I have a question about the replenishment fee. The people that are deriving their water from the Indian Wells Valley Water District. I have a question about the replenishment fee. Those are people that are deriving their water from the Indian Wells Valley Water.
We're hearing an echo. Could you? Do you have your computer and phone on or something?
I do.
Could you mute one of them? Preferably the computer, I guess.
Well, I don't know how to turn the computer off in the middle of this. I'm trying to shut it down.
Okay.
Yeah, let me see how I can do that. Turn the computer off in the middle of this. I'm trying to shut it down. Okay. Can you hear me now?
Yes, go ahead, Mary.
Okay, I have a question about the replenishment fee. Those of us that are deriving our water from the Indian Wells Valley Water District are paying a replenishment fee. Will the well owners be paying a replenishment fee eventually?
Are you talking? Are you referring to a replenishment fee after some type of a final judgment in the adjudication?
Well, it seems like we're paying right now. I'm an Indian Wells Valley Water District user. It seems like we are paying for future importation or of water, but the well owners are not.
Right. That's correct. Presently, right now, the water district is the only entity that's actually making payments pursuant to the replenishment fee.
Will that be mentioned in this lawsuit? Because that seems to be a big issue.
We're not really attacking that the allocation or the replenishment fee by way of the adjudication. There are other lawsuits that are probably more directly directed at those issues, and those would be those filed by Searles Valley and Mojave Pistachio. But based upon what the water district's doing with the adjudication, I can't tell you what's going to happen with the replenishment fee. It'd be speculation.
Yeah, it just seems a little unfair. That's my only question. Thank you.
Thank you, Mary. Next caller. Caller, thank you for your patience. You're on. Please state your name.
Yes. My name is Mike Neal. Can you hear me?
Yes, Mike, go ahead.
Okay. My question has to do with the makeup, the potential makeup, I guess, of a possible water master for this valley upon the completion of the adjudication. I looked a little bit at the Antelope Valley documents and stuff and noted that they had a makeup of various agencies, I guess, people appointed from those, and then there were 2 elected members. I think you said earlier from landowners in the area, something like that. one of the big problems with currently with our GA, it's been a current problem for a very long time, and people have been very unhappy that they did not feel that they have been listened to or represented properly because it was always a joint powers agency. And we had, two counties who represented it got the vote. One county of which probably didn't even have as many as 15 people in this basin. So I'd just like to hear some information, as much as you think is reasonable anyway, as to the process for determining, the makeup of the Water Master Board in the Antelope Valley after the adjudication was done and over, and what kind of voice could people potentially have in that process as far as advocating for an elected Water Master Board, so that people here in the valley feel like they've got a board that's going to actually listen to them, and that they've got some power in the way of electing them or unelecting them for that matter. So that's my question.
At the end of the day, the composition of the Water Master is the court will obviously consider recommendations from the parties, and that's usually what occurs. In the Antelope Valley, there was a lot of discussion. I think there was some talk about AVEC being the Antelope Valley East Kern Water Agency being the sole Water Master, and then there was discussion about an engineering firm. At the end of the day, I believe you're correct, it was a 5-member board that it's AVEC, AVEC, public water suppliers as a whole. There's a group there. Then Los Angeles County Water Works District number 40, one of the larger public water suppliers in the valley, and then 2 landowner groups. And there are certain votes that require supermajority, others are majority, depending upon the issues involved. And that was just something that the parties agreed to by way of consensus. What or who the Water Master may ultimately be in this case, I just don't know, but that's something that there will be, I'm sure, a fair amount of discussion about, and the parties will all have input on that.
Okay, looks like we're right on the call. Caller, you're on. Thank you for your patience. Please state your name.
Thank you. Hi, this is Kathy Brown calling. I hope you guys can hear me tonight. I've got 2 cell phones, one with a picture of you, and then my little 3G that's blowing out in about, 2 days? Can you hear me?
Yes, go ahead. Go ahead, we can hear you.
Okay, can you hear me okay?
Yes.
All right. First of all, I want to say thank you to everybody tonight. Thank you, Mr. Worth. Your explanations are spot on, and I really appreciate your depth in explaining everything. Thank you, Mr. Worth. Your explanations are spot on. Can you still hear me? I'm hearing an echo. I'm trying to balance these 2 phones because the TV went out. And I also want to thank Mr. Everts. Also, sir, you're doing a great job, in my opinion, of explaining all this because it's so complex. And I do have some questions. I hope I make sense. First of all, I want to say if I'm understanding this, thank you so much for the meeting tonight. It is extremely helpful. If I'm hearing this right, if I was to file my answer to support the lawsuit tonight, it would cost me $1,000. Is that correct?
That's not the plan. As I thought I'd mentioned earlier, the plan is. Oops. Uh-oh.
To wait till you get that filed with the court to reduce it. Am I hearing that correctly?
Yeah, I'm sorry. I stopped there for a moment because I was getting an echo. The first 18 parties in the case by court rules are required to file that filing fee. It's more than usual in our particular case because the case is what's called complex, which just adds additional costs. But the first 18 parties are technically required to pay that, but we do intend to go to court quickly to ask the court to waive that fee. So that's our intent, and we will be posting information on the district website to keep the parties and everybody apprised of what we're doing. And also, if you have specific questions, we're happy to receive emails and answer those as well.
Okay, I appreciate that's the fundamental understanding that I just was thinking, and you just reinforced that for me. I really appreciate it. Okay, that's a great idea. The other question I have friends living actually in Ridgecrest. They get their water from the actual Indian Wells Valley Water District, and of course they got the package, and they said, "Do we have to fill out this answer to the adjudication?" In my opinion, because I think in what I read, it said if you were within that district, you weren't being sued, so they assumed they didn't have to fill out the papers. That's what I told them. That was my opinion, and I said, but I don't know. I'll ask this question tonight. Do they have to fill out that answer to the adjudication, even though they get their water from the Indian Wells Valley Water District?
I think Mr. Worth answered that question the first time, so I'll let him answer it this time.
Mr. Worth, by the way, thank you so much. When you answered it, I kind of got it, but I didn't get all of it. So if you could reiterate it, I'd appreciate it.
Sure. What was the question?
Oh.
Mr. Worth, listen. You know, tonight I was. Let me make a joke. I was going to call in tonight because I think we all need a joke. I was going to say something like, is this the James Webb Space Telescope meeting tonight, or is it the Mickey Mouse Club?
You should have done that earlier in the night.
I know. That's my sense of humor. It's a little too late coming tonight. But anyway, my friends live in Ridgecrest. They're under the Indian Wells Valley Water District. Of course, They got, the legal papers and everything. They said, do we have to sign? Do we have to agree? Do we have to send in this answer to the adjudication? Because we're really not part of the lawsuit. It was kind of defined that way. Can you reiterate and explain that a little more?
Yeah. First of all, just to let you know, Doug and I are water district attorneys, and we cannot provide legal advice, tell you what to do.
Okay.
However, I will tell you this, that whether you file the answer with the court or not, if you are presently receiving district water, you will continue to receive district water whether you file the answer or not.
Okay, that was my understanding. They're going to be confused when I'm telling this. Okay, now the letter I received from Mr. Ervitz, dated December 16th, said your certified mail letter. Okay, on page 2 of that, when I look down here, let's see, at the top of the first paragraph, it says failure to participate. This is obscure. In the lawsuit could have significant blah, blah, effects on you. Okay, now it says that the district will request that any person that fails to appear in this lawsuit is going to be bound by any judgment. Now, that to me would just mean, whatever the court decides, I will, that's basically what they're saying here, in my opinion. Is that kind of right on, or, we just take what the court says?
You're correct.
Okay, thank you. I'm not an attorney. Okay, I'm not trying to be funny either. But anyway, the other thing I'm seeing here right below, it says, how do I participate? Okay, I'm becoming a party and to participate in the lawsuit. Right now, I really appreciate the intent of all of you, because we do need a solution rather than waiting 10 or 20 years. Especially, we're in a different critical stage, in my opinion, compared to Antelope Valley, because right now, the whole western United States is, drought. We're all in the red. So I don't think we have a lot of time to play around. That's just my opinion. And the sooner we get this fixed, the better for all of us. So what I'm saying is this: if we're going to participate in this lawsuit, you're basically asking us to do this, you would be working for me as a de minimis user, which I am, and would all this stuff, would I get a bill from you guys down the future, or is this pro bono? Maybe I'm not saying that right. I don't know. Can you give me some insight on that? I appreciate it.
I think I got the question. If I understood the question is, I represent the water district. That's my client in this particular case.
Yes.
With respect to de minimis pumpers, the discussion we had earlier, not sure if you heard it or not, but our plan is to go to court in March of this year and ask the court to put a pause on the requirement for de minimis producers to participate.
Mr. Everett, not to interrupt you, I apologize. I did get that, and I think you said that we could wait a little while. And to be honest, I don't have $1,000 to pay a fee. I checked in town to see if they could e-file for me. One attorney said, no, I don't do that. You'd have to get a paralegal, and that will cost you about $200 just to do that. So am I talking like $1,200 person if they're going to file. This is like, we're in bad economic times, as you know, and the economy is not doing too well, and, we've got so many negatives for, hitting everybody. So I do appreciate you getting on this as soon as you can to reduce the fees. But
we're working on that, we're working on that, and we will be posting information on the district website here very shortly with specific instructions on how to file an answer for those that would like to.
Okay, I really appreciate this. For the public record tonight, I'd like to throw this in as a comment. I think it is maybe pertinent. There's some real serious issues out in the Inyo Kern area with mail theft. There's crooks driving down the roads, the dirt roads, and they're opening mailboxes, and they're grabbing all the mail. In fact, one of my neighbors said, I didn't get any copies of any lawsuit. So he might have been one of the ones that had his mail stolen. And I say this in seriousness because the Inyo Kern Post Office, February 14th, is completely changing the 24-hour lobby that we had open for all these years. And because of vandalism, they're breaking into the boxes inside the post office. They're actually camping out inside the post office. So I want to kind of get that in. If you don't hear from some of these people out here, they just didn't get it. So I don't know what this is worth, but it's worth me commenting on as a factor that I think might be important for some people. And I wanted you guys to be aware of that.
Thank you.
Yeah, okay, I have a question, and I'm pretty wrapping this up pretty soon. On the actual legal papers that we received, the cross-complaint for comprehensive groundwater adjudication, on page 8, on the, 11th paragraph at the top, line 2, I would like you to define, clarify for me what this means. It says the district is informed and believes the cross defendants, rows 1 through 100,000, are the owners, lessees, or other persons or entities. Does that mean we have 100,000 people out here on record, or is that just a general thing here for rows?
Yes, I think she's referring to Doe defendants. If I understood the question, we're leaving open the opportunity to name as many people as we need to, and that was a number that was thrown in.
Okay, because when it says rows 1 through 100,000 are the owners, I'm thinking, well, does that mean you have them already?
No.
It didn't sound like it to me. Okay, moving down to paragraph 12, line 6, the district is unaware of the true names and capacities of cross-defendants, rows 1 through 100,000. Okay. When the district becomes aware of their true names and capacities, it will seek leave of court to amend the cross-complaint accordingly. Okay, here's my comment in question, and also if you could clarify this paragraph. My question is, how are you going to become aware? Do you have a plan in place? Does the district right now, are they working on some kind of implementation of a plan that will work on finding these names and all these other cross-defendants that you need? That's my question.
The two comments. Number one, happy if you have specific questions on the cross-complaint, shoot me an email. I'll answer them. And Mr. Worth doesn't know I'm going to mention his name right now, but in Antelope Valley, he represented a producer that was missed by Los Angeles County in the initial filing of the cross-complaint. So sometimes when lawsuits are filed, not all the pumpers are determined, so that's why those general allegations are in the lawsuit, so that if someone was missed or not identified, we can bring them in at a later point. But the language that you read is boilerplate, for lack of better terms. And it just happens.
I appreciate that.
Yeah,
okay, on page 10 of the same cross-complaint comprehensive groundwater adjudication, on paragraph 23, line 17, any judgment and physical solution, the proceeding approved by the court will be submitted to the DWR for review and approval pursuant to the water code sections here. Okay, my question is, once this is submitted to the DWR for review and approval, what is generally the period of time that they take to review something like this? If you would know that answer, I appreciate comment.
I wish I had a magic wand or crystal ball to answer that. I don't know how long they'll take, other than I can say that DWR has been very actively involved with both the water district and this basin. So I would feel confident in saying that they'll devote the resources they need to get this resolved as quickly as they can. What the specific time frame is, I just don't know.
Okay, I just thought maybe there was Well, we really don't know now, do we? Because of the situation. That makes sense. Probably a dumb question I asked. Okay, on page 12 of the same document that I'm talking about, excuse me, let's see, number 3, line 10. Okay, this is the prayer for relief, okay? It says, for entry of judgment, okay, the district would like the following relief. Okay, for entry of judgment against all cross-defendants, I'm a cross-defendant, who fail to appear in this action, that they be bound by any judgment and physical solution in their storage rights in the basin, if any, be limited to terms of the judgment. So I kind of looked at that and put a question mark. I said, wait a minute. As far as I'm concerned, it's the court that's going to make this judgment stuff. I mean, what's the district? Are they going to put liens on our homes here if people didn't, file papers in this lawsuit?
No.
It kind of, it's got a lot of people worried. Let's just put it that way.
Yeah, no, fair enough. And again, feel free to shoot me an email with specific questions. But the prayer for relief is a part of any complaint that's filed in any lawsuit where it's the party that's filing the lawsuit is making the request of the court. And you're absolutely correct that at the end of the day, it's the judge that makes the decisions.
Yeah, that's what I'm getting out of this. The other thing on line 4 on the prayer for relief, for judgment against all persons who, presently or in the future, own an interest in property. So therefore, if I sell my property after this is settled, that person is they're going to inherit what happened, obviously. Will that be disclosed to them with the realtors? There is a disclosure, in California. Will they be alert to that, potential buyers? If not, would they find that information when they have, going through escrow and asking for their title search to make sure all these little things would come up on purchasing a property? Is that how it's going to be handled? Do you know anything about that?
There will be a process that's put in place. Exactly how it rolls out, I'm not sure. I can't say, but there will be a process so subsequent purchasers of property do have knowledge of the adjudication and the ultimate judgment that comes out of this.
Yeah, because, when you buy a property, you want to know what you can do and what you can't do with it. Otherwise, you'll walk.
Right.
The other question I had, I'll kind of wrap this up. I'm a de minimis user, and I have 2.48 acres, and there's 3 other parties that we all own the well, but those 3 parties are totally going to be uncooperative in everything you want to do. So let's say I participate and support this, and I use the word if for legal reasons as well. The other 3 parties, when the judge comes down, that well sitting on that second property where I get my water, am I going to be protected somehow, or how are you going to deal with these other 3 people? They're totally irresponsible, and I don't want to say too much more about that situation. I'd appreciate a comment if you could give me one.
Yeah, 2 comments, and there was a similar question raised earlier this evening. Number 1, I would encourage you to file your own answer to protect your rights. And then number 2, we're going to do a little deeper dive into that question that you raised about one well serving more than one parcel. That seems to be an issue that's cropping up repeatedly. So I want to make sure that I've got it correct when I provide thoughts on that. So we'll post that on the district website as well.
Okay, I really appreciate you doing all this, and thank you, all of you, tonight for everything. It's been a very good discussion. I'd like to see more discussions in the future if possible. I know it's really difficult, but thank you all very much. I appreciate your time.
Caller, could you repeat your name, please?
Are you still talking to me?
Yes, could you repeat your name, please?
Oh, I'm sorry. I'm on this little phone. I can barely hear. It's so awful. It's Kathy with a K, last name Brown like the color.
Got it. Thank you.
Thank you very much. Good night.
I see a red light. That means there's no more calls. Just wait a second and see if somebody does call in. It looks like we might be done.
Power's still on.
Okay. For those of you that stuck it out, any last comments? I'll give you one more shot. Going once, twice, 3 times. Okay, meeting adjourned. Thank you for sticking around.